Hello, everyone. Hello, students, practitioners, professors, activists, and community members. We're so happy to welcome you back to day 2 of the UCLA Law Review's 2021 Symposium, Structural Inequality in the Law. My name is Ryan Garcia, and I am the UCLA Law Review Symposium editor. To quickly address a few formatting details, we will have 2 American Sign Language interpreters rotating during the sessions, and they will appear automatically alongside the speakers. During the webinar for closed captioning, please click the CC icon at the bottom of the Zoom toolbar. I would now like to take a moment to introduce Professor Bâli, who will be providing our opening remarks. Professor Bâli is a professor of law at UCLA School of Law. She is the faculty director of the UCLA Law Promise Institute for Human Rights, as well as a core faculty person of the Critical Race Studies program. She previously served as director of the UCLA Center for Near Eastern Studies. If I provided you with her entire bio, I would eat into her opening remarks session. So let me just finish by saying I have been extremely lucky to be a student in her critical courses, Public International Law and International Human Rights Law. Though I would have loved to have joined her seminars on laws of war and third world approaches to international law. We're extremely lucky to have you, Professor Bâli. Thank you for joining us today.
Thank you so much, Ryan. It's a great pleasure to be invited to join. Welcome, everyone, to the second day of this year's UCLA Law Review Symposium on Structural Inequality in the Law. I would like to begin by acknowledging, on behalf of the UCLA Law Review and all of the participants and co-sponsors of today's events, the Gabrielino and Tongva peoples as the traditional land caretakers of the Los Angeles Basin and the Southern Channel Islands. We are grateful to have the opportunity to work for and with Indigenous peoples in this place. As a land grant institution, we pay our respects to the ancestors, elders, and our relatives and relations, past, present, and emerging. I would also like to thank the Law Review team, especially faculty sponsors, Professors Sunita Patel and Kimberlé Crenshaw, Law Review Symposium editor Ryan Garcia, from whom you just heard and who I have the great pleasure of having had as a student, and editor-in-chief A.K. Shih for putting together this fantastic symposium, along with all of our co-sponsors, including the African American Policy Forum, the Epstein Program in Public Interest Law and Policy, the Promise Institute for Human Rights, the Critical Race Studies Program, the Criminal Justice Program, and the Veterans Legal Clinic. Yesterday, the symposium began with a fabulous opening roundtable exploring structural approaches to reimagining democracy in the wake of the white supremacist attacks on the Capitol and all that it rendered visible. Highlighting the capacious understandings of the law made possible by critical theory and social movements, the roundtable marked all of the ways we might understand the importance of the events of January 6th in exposing the contradictions between the formal race neutrality of the law and the stark reality of those who would refuse the rules of democracy if it means relinquishing white supremacy, to borrow from Cheryl Harris's succinct formulation. What was rendered visible, in addition to the performance of white dominance at the Capitol, was also the degree to which Black and Brown membership in the polity remains contingent. The mundane reality of racialized policing that explains the repression of the summer's racial justice uprising, contrasted with a spectacular enactment of police deference to white insurrectionists. But in engaging these themes, the roundtable also reminded us of the many emancipatory frames, the acts of radical reimagining, in the words of Amna Akbar, that social movements armed with the tools of critical analysis and strategic lawyering have placed on our collective national horizon, enabling us to envision the contours of an abolitionist, an anti-capitalist, and an anti-colonial future. In the second panel yesterday, the panelists helped us work through conceptions of public safety in the context of deep structural inequalities. It was an invitation to think critically about what we mean by public safety, by unpacking which communities' safety counts, and also how public safety often means safety from the other, from marginalized communities that are left exposed and whose safety is breached in the name of protecting the privileged. By explicitly racializing how we think about public safety, the analysis demonstrated how racism stands in the way of realizing an emancipatory conception of public safety and instead allows the language to be deployed for the purposes of subordination, domination, dehumanization, and even premature death for the racialized other. across an astonishingly broad swath of themes, from abortion restrictions to prosecutorial practices, from Symposium faculty organizer Sunita Patel's piercing analysis of how carcerality weaves its way through and wraps itself around the provision of hospital care in the Veterans Administration context, to a remarkable analysis of how unexamined methodological choices to de-emphasize race affects knowledge production in criminology. Across all of these themes, the panel provided fresh thinking about how policing and carceral practices themselves undermine public safety in the midst of a public health emergency and much more broadly in this country. Finally, our day came to a close yesterday with Kimberlé Crenshaw's incredibly generative closing remarks, reminding us of the intergenerational character of the conversations we are having and providing us with the analytic tools to think through the national epidemic of racism made stark by the insurrection, returning to the morning's themes, as well as the brutal death toll of a global pandemic this past year that has exposed once more the devastating effects of systemic racism and structural inequality in this country. If the goals of our symposium are to examine the role of the law in entrenching structural inequality and racial subordination, and to imagine how to transform these structures and institutions to serve equity-producing ends, we could hardly have hoped for a more insightful or inspiring first day. And that just sets the stage for what we might expect today. Today, we will have an equally bracing set of engagements with the questions of social movements and institutional change and how we might imagine the terms of emancipation from conditions of structural inequality. Social movement theory and movement lawyers have long been engaged in projects of reimagining and changing institutions. Today, we will pick up the questions raised in our panels yesterday, namely, how do we facilitate a more inclusive future and how might legal frameworks connect to and build out from this moment of racial reckoning. Our first panel will explore the possibilities for social movements to leverage strategic litigation, public defense, and also non-legal strategies to promote change through fundamental and structural reforms. We are in for a day of fabulous interrogation, conceptualization, and reimagination across a host of conversations. And to begin that day, it falls to me now to introduce the chair of our morning panel, Professor Scott Cummings, who is Robert Henningsen Professor of Legal Ethics and Professor of Law at the UCLA School of Law, where he teaches and writes about the legal profession, public interest law, law and social movements, and community economic development. He is the faculty director of the Legal Ethics and the Profession Program and longtime member of the UCLA David J. Epstein Program in Public Interest Law and Policy. Welcome, Scott.
Thank you, Professor Bâli. I'm so privileged to be able to introduce this exciting panel on social movements and institutional change, which will explore the potential of progressive social movements in this particular moment, not just to change the law, which is always only the starting point, but to shift culture, to build power, and to transform democratic systems. And in attempting to do so, we want to really think critically and strategically about the role law plays as both a target and a tool of institutional change, which is to say, what are the best ways for lawyers, legal institutions, and law schools to support and strengthen social movement mobilization that fundamentally challenges structural inequality and reimagines a different, better world? We know from history that structural inequality is resistant to simple legal interventions. And yet we also know that law is a tool that must be used in tandem with other forms of power, and that we need to invest in and protect a notion of law that creates opportunities for transformative change. As we have heard from the incredible voices at this conference, rethinking the relationship of law, social movements, and structural change is happening in real time outside of these spaces, powered by the global racial justice uprising and extending to the range of local efforts to respond to the urgency of material deprivation, the loss of jobs and housing, and massive health disparities that have long been with us, but even more starkly revealed and exacerbated by the pandemic. As lawyers and law students, we must listen and learn from these movements how to effectively wield law to confront racism and bend the arc of justice. This is particularly true since we also have seen the left uprising confronting a counter movement that is not just highly mobilized, armed, and violent, but also importantly, highly legalized, supported by an army of lawyers who have helped devise a strategy to not just undermine the election, but to empower white supremacy. It is in this context that we must reimagine how we think of law, not just as a tactic, but as an integrated part of left progressive social movement strategy, one that can help us realize the promise of a more just society, and not just here, but around the world, as these movements for and against emancipatory change are indeed globally interconnected. So we have an incredible and inspirational group of speakers to address these issues that I'm really proud and excited to introduce as the moderator and engage with them as one of the panelists today. So each of us in this format is going to give brief introductory comments, and then we'll have a facilitated conversation before opening it up to audience questions. So you can use the Q&A box at the bottom of your screen to ask questions. We will try to get to as many as we can as we turn toward the end of our session. So let me introduce our panelists. Shaun Ossei-Owusu is the Presidential Assistant Professor of Law at the University of Pennsylvania Carey Law School. Purvi Shah is the co-founder of Law for Black Lives, and Rebecca Tosi is the Regents Professor and Faculty Co-Chair of the Indigenous Peoples Law and Policy Program at the James E. Rogers College of Law at the University of Arizona. As we turn it over to the speakers, I do want to just remind us all to speak clearly and slowly for our ASL interpretation. And with that, I will turn it over to Professor Ossei-Owusu. Thank you very much.
Great. Well, good morning, everyone on the West Coast, and good afternoon to everyone on the East Coast and Central Mountain regions. I'm excited to be here and part of the conversation, and thankful for the invitation. So I'm going to spend a couple minutes chatting about the prism through which I think about social movements, and that's through the lens of legal education and the legal profession and public interest law particularly. So I think about social movements through the lens of public interest law because much of my scholarship and my forthcoming book is about the history of civil and legal aid attorneys. And in the story that I tell, which builds from the work of legal historians and legal scholars, Professor Cummings being one of them, I show how these attorneys have been central to a variety of movements for social justice, whether it be abolitionism in the 18th, 19th centuries, progressive era movements that sought to attenuate capitalism run amok at the turn of the 20th century, the civil rights and women's rights movements, and current movements to address mass incarceration. So we know how lawyers play a role in these movements generally, but I write about how my focus has been on how criminal and civil legal aid attorneys have been important to these movements. I focus on legal education because it's the subject of my next major book project and because it precedes legal practice. And it's the area where I, as a law professor, think I can have some kind of immediate impact. And for the professoriate as a whole, a place where there can be certain kinds of accountability. And so I'll spend a few minutes here talking about legal education. I'll end with a short discussion on public interest law. I'm happy to chat more about this when we open any of those issues when we open the conversation. So at least in the classes that I teach, I believe it's disingenuous to seal off politics from legal education. And so in these classes, the classes that I teach, crim, legal profession, law and inequality, politics are inherently involved. And so legislatures are political bodies and they draft the statutes that are subject to what we talk about in a class like criminal law. Courts, where some judges are appointed by politicians and others are elected, are also influenced by politics. To be clear, that doesn't mean that they don't apply the law that we spend 3 years learning and try to do so. It doesn't mean that they don't try to do so in a fair and consistent fashion, but that's more of an aspiration than it is an empirical fact. And so when it comes to thinking about legal education, I try to equip students with the background necessary to support social movements and to try to bring current conversations into the classroom and anchor them in the cases that we read. So this is a high wire act because there's always a concern that conservative views aren't given enough space to breathe in the classroom, or that a professor is not left-leaning enough and too solicitous to the status quo. Then there's the question about which social movements we're talking about. There are some social movements with antithetical interests, and Professor Cummings talked about this, mentioned this in his introductory comments. And so here is where I think curation becomes important. And I try to include outside reading, and there I try to bring a wide set of views, the widest set of views possible, to force students to think about an area of law rigorously. I don't do this because of intellectual diversity, although I think that's a worthwhile goal. I do it because I believe students need to be able to best confront the best possible arguments, irrespective of ideological leanings, and that can be uncomfortable. It can be surprising for liberal students in some instances to confront the fact that conservatives might have views on mens rea reform or the fiscal unsustainability of the criminal justice system that sometimes aligns or outstrips their own opinions about mass incarceration. It can be uncomfortable for conservatives to confront the long-standing, dogged racial imbalances in our criminal justice system. And I think it could be uncomfortable for many students to play out abolitionism in the context of something like homicide, or confront arguments around carceral feminism. So this idea that the state has been a primary way of dealing with issues of gender-based violence. But I think it's the inclusion of these kinds of topics that do a few things. First, it brings the topics into the classroom and makes something like criminal law not just about theories of punishment, but it connects them to issues on the ground that are tied to social movements that I suspect many students come to law school for. Second, and to get at an earlier point I mentioned, it gets people who have a particular set of commitments to really confront an array of arguments, which I think happens in law school, but in ways that are apolitical. I don't think it behooves anyone to get a kind of legal training that doesn't prepare them to confront a range of arguments that are against their position, as well as the range of issues that they will confront, but are simply presented in antiquated English common law cases. Third, I think it can prepare students to begin to think about their legal education in a more practical fashion. And I think this is the kind of education that I think might suit people who are interested in movement work, where they learn the content of the rules, the tests, the standards, and the defenses. But again, they're tied to real issues. Now, I know there are many students on the call, and so I want to say a few things. First, I think outside reading is critical to doing this kind of legal education work that's tied to movement work. Obtaining a kind of robust legal education is simply not going to come just from the law school. It's going to require reading outside of our casebooks, and that's not a fun proposition, particularly for 1Ls. But the reality is, developments as diverse as the Federalist Society on one end and critical race theory on the other started in part out of reading groups by law students who were dissatisfied with their legal education. And so when we think about social movements as organized collectives of individuals or institutions working towards certain kinds of socio-political goals, it becomes important to remember that legal education can give you some of the raw tools that are necessary to support social movements, but it definitely doesn't provide it in a prepackaged manner. It requires work, and to be frank, it doesn't match the kind of work that people on the ground are partaking in, whether it's community organizing, protests, uncompensated labor, putting one's reputation on the line, and in some contexts, physical bodies on the line in service of a particular cause. And so I think that's important to remember. Second, and finally, I want to move to this conversation about the legal profession. You know, there are different sectors of public interest work and they have different implications. I think most generally, it's important to be sober about the strengths and limitations around different kinds of public interest work and their relationship to movement work. So there's direct service work, which I think is often subject to a critique that it doesn't move the ball or spur large scale change at the pace people desire. And that has some partial truth, but I think it rests on a somewhat limited view of the importance of direct services. But this area of work is also has meaning for people who receive it, whether it's the person working with the civil legal aid attorney to get public benefits, or the public defender who helps keep people out of squalid correctional facilities. You can always conjure up a critique of this kind of work. So civil legal aid doesn't upend the system of capitalism, or public defenders simply reify the penal status quo. Perhaps, but I think it rests on a grand view of how social movements work and minimizes the importance of direct services. On the other end is the impact work you find in organizations like CCR, NAACP, or ACLU, which I think in many ways is ideal because our legal system is saddled with a lot of problems that we want to end in some instances or change. And this kind of work can be criticized as not doing the immediate on the ground direct services. And this is true to an extent, but I think overlooks the local work of these organizations. Moreover, I think movement lawyering is applying pressure to the assumption that impact litigation doesn't do this kind of direct work. And I'm sure we'll talk more about this in the conversation. These kinds of organizations are engaged in the kind of on the ground organizing. And so I say all this to say that there are various permutations for how we might think about when and where students enter when it comes to social movements. But I think a crucial stage is legal education, which requires professors to reimagine how they approach legal education and entails students doing some of the outside work to complement what can be a very outdated legal curriculum.
So thank you. We are now going to turn it over to Purvi Shah.
Thanks so much for those comments and for this conversation. And I think this entire conference is really confronting, I think, a really critical question for us as lawyers, right? How do we, in this moment where we're trying to grasp for something new and what has been is not meeting our needs, right? What is our role in that? So I come to this conversation, primarily out of about 20 years of playing a role directly supporting social movements, sort of being a movement strategist at varying levels, at the local level, at the national level, and occasionally at the international level. And really, I also come to this conversation primarily as an infrastructure builder, really thinking about both the what are we trying to achieve and what is it going to take? How do we have to be? What are the kinds of institutions and roles we have to play in order to address this question of systemic injustice, of the sort of building the alternative. So I wanted to kind of ground my questions because I think oftentimes in the intersection between sort of vision and strategy and practicality, for me, I often ground all questions that I think about in sort of the why, the what, the who, and the how. And I know that sounds simplistic, but I feel like it always keeps me focused in how I think about, kind of bridging between big ideas and a solid practice. And so for me, I think when I think about the why, I think it's always helpful for me to remember what's the moment that we're in. And I feel like partially because there are answers in history and there are patterns that repeat themselves, but also I think if the question is what is our work, that has to be grounded in the current moment. So I feel like if we think about these last few years as what has this moment taught us, I think what we are seeing is more, elites, middle class people are learning what poor working class marginalized people have known forever, which is that our systems in America are flawed. they're corrupted and they're not working, right? So whether we look at things like healthcare or our prison system, whether it's the COVID response, the rollout of the vaccine, I mean, there's no shortage of examples. And most importantly, I think in this last period, also the institution and the sort of the institutions that undergird democracy are incredibly flawed and corrupted. And so I think we're also in this moment of like a reckoning around racial justice, the origins of this country, the intersections between, our history with slavery and anti-Black racism, and this question about also, climate justice, right? We're sort of in moments of peril that I think are asking us to think about what is it that we have to remake urgently in order to have a world. So I also think in these moments, we're seeing kind of a rupture, right? It's a sort of rupture moment, and a rupture moment where our conversation is changing, right? We had the largest, last summer had the largest mobilizations in history with the movement for Black Lives and the George Floyd protests. We're seeing different conversations, different sort of awareness about the issues of our essential workers. Now, a rupture is just that. It's a rupture, it's an opening. Right? It's a moment the curtain pulls back, someone takes the red pill or whatever analogy you want to use. But it's certainly, most importantly, its crisis is creating both, I think, opportunity and challenges. On the opportunity side, it's a lot of what we mentioned, the discourse is changing, our articulation and our sophistication sort of in the common sphere, we're having different conversations. And I think more diverse groups of people are realizing that our existing systems are corrupted and they don't work. And in fact, we've been told a story that they work perfectly, but in fact, we realize they are working perfectly with a different purpose in mind, not the ones that perhaps we thought, a more egalitarian purpose. And so, but at the same time, I think the challenge we have is that rupture is an opportunity for a lot of different types of people, not just people that are bending the arc towards, freedom, justice, liberation, sustainability. We see that this moment is also an opportunity for people to present a different vision. And those forces are also, so when we think about systemic change, institutional change, for me, it's really important to know what is the opportunity we have and what are the threats that are also coming forward. And so we see, white supremacy is reshaping and reformulating in this moment and trying to take control of institutions or to sort of exert an agenda that has been long-standing, but they're also in a moment where they're trying to recapture institutions. And capital is trying to maintain the status quo, peace, right? We want the machinery to keep working. When folks start to get disruptive, the system doesn't work as we want it to. So I say that sort of as grounding. So where does that leave us, right? As lawyers, I think our positionality or people with legal skills is we're kind of trained inside, we're trained by a system, we're taught, and as Shaun just expressed very clearly, we are socialized inside a system. And primarily our skills have us operating within existing systems, right? When we look at law, it's like we are literally trying to use existing systems. And then what do we know about law? This whole conference, and many of you, this is not news, right? But it's like law is a malleable tool. There is no inherent logic or ethics to law. It is a tool that is malleable and used. And its origins come in terms of keeping power in the hands of the white, wealthy, and the powerful. So where does that put us inside this? Both our skills come from a system that we know is corrupted, that is exposing, its flaws are being more and more exposed, and crisis is heightening. So I feel like our work in this time, right, the work of lawyers, I think is to confront the question of, are we trying to tinker at the margins of change? Or are we trying to wholesale transform the system? And I set that up as a binary, but I actually think our work in this time is actually to do both. I think conscious lawyers have to do both of those. And so let's talk about what is our work. And I'll just lay out my sort of thoughts about 5 or 6 really important things that I think lawyers of conscience, right, however you articulate your role in the ecosystem, a direct service lawyer, an impact lawyer, a movement lawyer, community lawyer, we can talk about the sort of, lexicon of identities and roles and tactics, but I want us to elevate a level up and say, regardless of where you sit in the ecosystem, what are the things that we need to be doing? I think first and foremost, and this won't be a surprise to those of you that know me, first and foremost, we flank movements and we work to build power. And the whole idea that when you're in this contestation and in a disruption, like you have to actually think about forces, aggregating certain forces to exert pressure on other forces to either change, protect, whatever it is. So organized groups of people have always been the engine of how we are able to create any social change for the progressive side or for the regressive side. And so for us, if we're interested in these questions, first and foremost, we have to understand that our work is not just about winning cases or changing policies, but ultimately it's changing culture, systems, and power. And for me, there's no way for us to do that as lawyers if we don't connect to people that are actually trying to do that at a mass scale, right? I think there are a couple of other things. I don't think that answers all of the things that we need to do. I would say there are about 3 or 4 other things that are really important. I think as lawyers, we can help to make meaning of the moment. There are so many conversations going on about law, about rule of law, about systems, about democracy, the Supreme Court. And inside that, you'll see there are people who really get the sort of way the systems are not foolproof, where they're not sort of they don't have like they're not self-executing. You see that kind of narrative getting out there in the media, but you also see a way the hegemonic power and the way we think about law is also super present. There's sort of like law will save us, courts will save us, elected officials will save us. And I think in these moments, lawyers can do a lot to kind of actually make meaning of the way systems like are actually what their origins are, how they're designed, what their limits are, and what the possibilities are, right? So like not throwing the baby out with the bathwater, but a measured, like actual making meaning of systems that are flawed, that are rooted in principles and values that are not aligned with perhaps the world we want, colonialism, imperialism, racism. However, like we need to speak truth about that and make meaning of the status quo and what's happening. I think the next thing we can be doing is helping build a bigger we. Like in these moments of rupture, there's a positioning of us versus them. And it's really important that we think about our role, both in our sort of cultural and narrative power we have in the world and legitimacy that we have in the world as elite professionals, but more importantly, in the way that our work can actually stitch together people and actually say the issues of climate change are not disconnected from the issues of racial justice. The issue of the young person who's fighting the school to prison pipeline in their schools is not different than the issue of folks fighting pipelines. And so how we can help kind of bring in our work, in our tactical day-to-day work, how can we build bigger we's? How can we stitch together the kinds of communities and people and movements that are necessary to actually push back on all of the forces that want to keep our systems working to oppress, marginalize, and elevate certain people over others? I think the most complex thing we have to do is kind of walk and chew gum at the same time. I call this, this is the high line, the tightrope, is that we have to use the existing system to keep people alive, to push back, to demand accountability, right? To exercise democracy, as flawed as our understanding of democracy is, while we simultaneously support movements that are actually trying to reimagine, redefine, saying what could it look like to have democracy that's not rooted in the ideas in capitalism or in colonialism, right? And some of this is not new, but how can we actually see? I think sometimes we think to be a conscious lawyer, it's that you have to only be doing the dismantle the system. And I think it's like we've got to be able to do both. Obviously, the North Star is redefining and reimagining systems that are rooted in a completely different set of values and politics. However, in the meantime, I think we have a unique set of skills that allows us to work to use the sort of defensive and offensive fights in a way that can build power and aggregate people together. And continue to seek accountability for bad actors inside flawed systems, right? So to me, I'm like, this is the walk and chew gum. We know this system isn't real. We know law is not inherently logical or doesn't bend towards justice, but at the same time, we are going to use it to its fullest extent as strategists while we try to make space and clear things out of the way of movements that are trying to actually completely redefine what it is that our systems should look like. I guess I'll say just a couple more things because I want to switch to the how. There's more to say about the what, and I've put out some big concepts, but there's more brass tacks in there. But I think the how comes back to a range of things, because I don't think, I feel like when I've now been doing movement work for 20 years, I think when I was younger, I really felt like all that mattered was I had to have the right politics and the right analysis. And I think that is an incredibly important part of how any of us can show up to this. You can't really, and history, you can't really understand how to be a conscious actor inside this evolution, this long arc that we're trying to make towards a different world. But I don't think that's enough. We need particular skills inside that to become good strategists. And I think kind of observing a lot of our conversations over the last few years, I feel like there's maybe 3 things that I want to lift up. I think one, this idea of a long arc. I think when we're lawyers, we are tacticians. We are oftentimes brought in to keep someone's home, to fight a bad policy. Those sometimes have very short timelines. They can be a 30-day timeline, or it can be even a longer timeline of 5, 7, 10 years, but they're still not in the long arc of strategy. And I think if we look at the forces that were coming against us, I think they have been executing a 50, 100-year strategy. And so I feel like this ability to be able to look at what's right in front of you while you simultaneously think about how it fits into a much longer arc that you're likely not going to have a part in a majority of that is a key skill that I think we have to develop. I think 2, it's about holding what we want to be possible inside a sober and honest assessment of where we are. I think sometimes, we have this idea of like what matters most is that our demands are the best, without a clarity of like, where are we in the power to win this demand? And to me, that's not about being a reformist or not being radical. To me, it's about being a good strategist. If you can't figure out and understand where you are and how much power you actually have, then it's very impossible to calculate how you're going to get to the win that you need. So I would say this idea of like a critical analysis about where are people at, a sober assessment of our own power. I would say the ability to engage in debates. We are missing this muscle so deeply in our movements. Everything gets distilled into sound bites. When we say we're pro, like, what does it mean? What is the democracy that we want? How do we have very depthful conversations about what it is and what it's not? When we talk about the state, what is the role of the state that we want, right? We talk oftentimes, we don't want the state to do X, we don't want it to do Y. Well, what is the vision of the state we want with a lot of nuance? And then I think getting really precise about the role you're gonna play. I feel like there is a lot of my mentors, we have to build a movement in which, one, it resonates with the hearts of everyone. I think if we're building a movement that you can't get millions of people behind, it's not a movement that actually has the ability to win. And so for that, I think it means like there's got to be a lot of lanes and a lot of roles for a lot of different types of people. And so I think this skill to say, where do I sit in the ecosystem? Where do people with my values and politics, where are they? But where do we sit in different parts of the ecosystem? How we can run multiple strategies and tactics at the same time. And I think we're going to need to do that. And I don't mean that in watered down and like everybody's a part of it. I mean actually like a higher level of preciseness about, what are we fighting for and what are the variety of strategies we'll need to move in order to actually win that. Some defensive things, some offensive things, some using the system, some transforming the system. Okay, well, I think that's kind of the heart of what I wanted to say, really. And I think I'm really looking forward, but this idea of like the tightrope of the new way of being, the new way of thinking that helps us redesign systems while we simultaneously use the existing systems to their fullest degree to actually keep people alive so they can organize, they can aggregate, they can build power and start to actually have the balance of forces that can actually transform. So that may have been a little bit longer. I'm sorry if it was, but I would love to pass it on to the other folks on the panel.
Thank you. That was amazing. And I'm just so excited about the way that this conversation is already building and really like the frame of the tightrope. And I think it's a good point of segue into comments that I would like to give, switching off my moderator hat here because I am contributing a paper to the conference. I did want to take a little bit of time to share some ideas here before turning it over to Professor Tosi to round out this first part of the conversation. And again, the idea is to sort of provide thumbnail overviews of our thoughts as an invitation to the discussion part of this panel that we're going to have next. So I really think of this as sort of building directly on Shaun and Purvi's just really galvanizing contributions, and wanted to take 5-7 minutes here to bring into the conversation two different themes. And one is to think about the relationship between law and social movements from an international perspective, and to think about how we should understand and engage with global movements for equality, movements that often take cues from what happens here, and in fact are networked and interlinked with US movements in really important ways, but are also their own sites of resistance and innovation that offer us lessons for what we can do here and what we can do better. The second theme that I want to bring into the conversation, and this is actually where I want to start, is perhaps the most controversial legal tool within social movements, which is the idea of strategic litigation. So strategic litigation centers courts as arenas of struggle and uses legal claims advanced through targeted lawsuits in an effort to provide benefits that go beyond individual parties. So seeking to reform law, to change how institutions function, and ultimately to shift power. Strategic litigation was, of course, pioneered by the NAACP more than 50 years ago in its challenge to school segregation, culminating in Brown versus Board of Education. Perhaps the pinnacle achievement of strategic litigation, maybe worldwide, Brown continues to endure as this paradox. It's a towering symbol of equality, inspiring racial justice movements around the world, even as it has come to represent the profound limits of legal justice in the United States. And critical scholars have stressed the demobilizing effect of court decisions like Brown on social movements, and have questioned the legitimacy of representation by cause lawyers who do not always listen carefully to the voices of communities they seek to represent, invoking here Derek Bell's famous critique of lawyers serving two masters. And yet, despite these critiques, litigation as a tool of institutional change not only has endured in the United States, but it's really grown exponentially in importance if you look at the number of claims and the frequency with which political disputes are legalized, the ways in which law is actually weaponized on both the left and the right. And we saw this during the last 4 years in the more than 400 lawsuits filed by the ACLU against the Trump administration, challenging a range of policies, including the Muslim ban, family separation, the removal of children seeking asylum at the border, and many, many others. We've also seen, as has been alluded to already today, the rise of strategic litigation on the right as one of the most dramatic outgrowths of the rights revolution. Conservatives learn how to strategically litigate and how to consolidate power in courts to effectuate their legal and broader political goals. And I think it's important to note that although the Capitol insurrection has deservedly received the most attention, Trump lawyers have led an assault on American democracy less dramatic, though perhaps no less consequential, by filing over 100 frivolous and enormously dangerous lawsuits designed not just to overturn the election, but really to undergird and expand conspiracism and sow fundamental doubt about the integrity of American democratic institutions. And this leads me to just want to reflect for a moment, and I think this builds really directly on Shaun and Purvi's comments on what we know because of the enormous experience and body of research over the last 50 years in the United States about the power and the limits of strategic litigation, and how we should think about its use now in relation to movements for economic, racial, climate, and other progressive justice movements in a system of mobilized violence and really locked in right-wing control of federal courts. So I just wanted to offer a few thoughts. And again, these are kind of invitations to further conversation in the next round here. First, when we think and consider the potential of litigation to promote progressive institutional reform, really centering this notion of institutional reform and what it actually means, we do know that litigation works best as a means to an end. So court decisions are never the terminus of social movements. They are always a moment for deepening mobilization and widening its reach, a statement of legal justice that movements can elevate in the media to shift culture, use as a vehicle for more organizing, or as a lever to promote political change. So I study legal activism in Los Angeles, and I think of the litigators here recently who have filed suits to shut down eviction proceedings, to challenge police department use of force, to protect gig workers unfairly denied labor protection. And these suits matter because they result in concrete gains, right? Money, injunctions, but they also matter because they spotlight the need for ongoing activism, monitoring, implementation, and institution buildings. So lawyers flood eviction court, not just to help people with urgent legal needs, but also to spotlight the need to cancel rent debt during the pandemic. The other point to emphasize is that strategic litigation works best when it's part of an overarching plan that's designed in collaboration with non-lawyers, community members who understand litigation as part of a long-term process of systemic change and power building. So effective movements always have inside and outside strategies, always engage in bottom-up protest alongside top-down efforts to influence decision makers. And litigation has always been and has to continue to be a tool in this mix. I just published a book on movement lawyering in the labor and immigrant rights movement over the last 25 years in Los Angeles. And I wanted to just draw attention here to the movement for day labor justice, where 20 years ago, the county of Los Angeles passed a law making it illegal for day laborers to seek work in public space, with a really devastating effect on their livelihood and their safety. After a litigation campaign spearheaded by MALDEF in collaboration with the National Day Labor Organizing Network as a close partner, those laws were systematically struck down. And now, although conditions remain extraordinarily difficult, we see the county actually using its own resources for the first time to enforce wage theft laws on behalf of day laborers. And this change is not a fundamental sweeping change of the marketplace for immigrant work, but it is consequential. It matters to people's lives, and it underscores that litigation, that for litigation to work, it really must be controlled by the movements on whose behalf they're wielded. And this brings me really back to where I started, which is the international arena, and going from the local to the international. One of the issues that I have been studying in relation to the themes of this conference is the dramatic rise of the use of strategic litigation outside of the US. So in Europe, for example, over the past 20 years, the number of claims filed in the European Court of Human Rights, which is one of the two main European supranational courts, increased more than 1,000-fold in the last 20 years, while cases claiming discrimination rose by roughly 600% during that same period, which is an astonishing increase. This increase includes the seminal 2007 case holding that the segregation of Roma children in special schools in the Czech Republic constituted racial discrimination under the European Charter of Human Rights, a case that was widely hailed as the quote-unquote European Brown. And this is just incredibly striking, right? A half century after the American Brown, after a generation of backsliding from that decision and backlash against it, the very same tools pioneered in the US struggle are being deployed to advance equality elsewhere, with very similar debates about legitimacy and limits. And so as I close, I just want to say that in our discussion of the scope of institutional reform, what that actually means and how to achieve it, I do want to say that I think it's important to reflect on strategic litigation itself as a sort of global export that is shaping and influencing global anti-racist movements. And we need to ask, is this litigation outside the US different? Is it more embedded in social movements? Is it more effective? What are its aims and what are its aspirations? And what can we learn by expanding the geographic frame of our own understanding, moving outside of the US debate to more effectively mobilize law to challenge power? And I'll just close because I want to, again, use this as a basis for conversation, just to mark that in the movement against structural inequality, we have to be mindful that the world is indeed watching, but also that it has much to teach us about how to do this work and to maybe do it better. So thank you. And with that, I will hand it over to Professor Tosi.
Thank you so much, Professor Cummings, and thank you to all of the panelists for those amazing remarks. I'm so honored to be included in the panel, and I thank Ryan Garcia and the editors of the UCLA Law Review, as well as the outstanding UCLA faculty for making this event possible. I've been in 2 conferences simultaneously, so I'm looking forward to hearing the events of yesterday. My comments today are going to focus on Indigenous rights, Indigenous self-determination in particular, but I want to tie into a number of the comments that have been made and the larger discussion of structural inequality, of course, because we're positioning Indigenous peoples as marginalized within the structures, both of the United States, but also, as Professor Cummings just pointed out, there's an analogous position in Latin America, in Africa, in many of the countries where you find Indigenous peoples. It's the same type of a movement toward some sort of parity or equality. But it's not necessarily the equality of citizenship, although that is a big part of it. That's the internal part. The other part of it is equality as peoples, as distinctive, autonomous peoples who have always been there and are tied to the land in ways that no other people are throughout history. Now, critical race theory, and you have the leading scholars in the entire world at UCLA, but critical race theory has always made that point that the law constructs race, and then in turn, race permeates the law either structurally and in a formal sense, as it did during formal segregation here in the United States and under the institution of slavery, but also informally through these procedural mechanisms. And if today you thought about, what happens, for example, in NEPA processes, where you want to look at the impacts of mining, for example, on a community, and you do a NEPA analysis. Well, is that procedural or is it substantive? Is it telling us what the human rights of the people are and what those harms are going to be over the next generation or 2? And I would say no. That statute is a procedural statute, and there is much injustice that arises from that. Now, the next thing I want to do is just structure the conversation, as I understand it, around democracy, which we're positing is inclusive of our Congress and our executive structure and the court systems, the federal court systems, and all of those structures protect the rights of federally recognized Indian tribes within the United States that have this unique relationship with the United States government. Do we want to get rid of that structure? No, that structure needs to be certainly have some work done on that structure so that conditions of justice can prevail. But we're not seeking to get rid of those structures. And so the nuance is really, with respect to social movements, the recognition that our political process, our democracy is subject to corruption. As Purvi, thank you for your work. That is absolutely outstanding over 20 years to acknowledge the level of corruption that exists. And you could see that permeate the administrative structure in the last administration with respect to agencies. We have to be honest about how that has been owned by these special interests. Now, what does that mean? It means that social movements, and Cheryl Torres and Lonnie Guinier make this very powerfully in their work. Social movements are the real participatory democracy. That is the grassroots. That is the people speaking about what the needs are. And that is the voice that you are giving life to, that all of the colleagues on this panel have discussed. So how do we see that emerging today? Well, in this world of intersectionality, we are looking at, for example, the constellation of interests in the environment, climate justice, environmental justice, and movements such as No DAPL, the Dakota Access Pipeline. What was that doing to the communities? Keystone XL, the Bears Ears National Monument in Arizona, Oak Flats, sacred places being owned by corporate interests. And oftentimes these are international movements. And so Professor Cummings, you spoke about looking at the global instance. If you look at the role of those international corporations coming in and recolonizing indigenous peoples and lands in the United States under US law, that is unacceptable. How are we going to give voice to that? So part of the impetus of social movements today around climate justice, environmental justice is very powerfully linked to Indigenous rights, but it is not coextensive. And I want to make that point that as we construct the law, we need to give account to the historical underpinnings of the law and also see how that has been navigated in prior eras. And I know we're supposed to keep to 5 minutes, so I'm gonna do 2 centuries in 3 minutes or something like that, which is really an undertaking. But if you thought back to the colonial era and the doctrine of discovery, that idea that civilized Christian European nations could come into lands occupied by non-Christian, quote unquote, non-civilized people, Indigenous people, claim title and say, well, you have a right of occupancy until we extinguish it by purchase or by conquest. Well, that's imported into US law, and Johnson v. McIntosh, one of the pillars of the Marshall Trilogy. That's not going away. We are living with that legacy today. Second era, the dependent nation, the wardship status, not a citizen, not a separate people, under the thumb of the United States and no constitutional rights, religion banned officially, Christian missionaries assigned as government agents to the reservation, no opportunity to go to court. If your children were taken and put in boarding school, you had no right to visit them, no right to protect your family. That was the status of ward, and that lasted until 1924. So what do we do under citizenship? And here, the Civil Rights era, that Brown versus Board, that thinking, the Civil Rights Act of 64, the Voting Rights Act of 65, there was a nuanced litigation strategy to enfold Indigenous peoples into the protections that were being extended to Black and other people of color who had been denied those rights. That is a powerful history and an example of intersectionality. Was it sufficient to vindicate rights? No. So in the current era, we are in the era of self-determination. International law, once again, human rights law, the 2007 UN Declaration on the Rights of Indigenous Peoples says Indigenous peoples are peoples with the same moral and political right as all other people in the world. That is a first. It took until 2007. The United States didn't accept it until 2010. President Barack Obama gave his consent, and the State Department said, you know what? That is what we have been doing with federal Indian law. Is it? No, it's not. There are many rights in there, and that is that intergenerational attachment that Indigenous peoples have to their land. How do we recognize and affirm that? I thank Professor Bâli for starting this morning with the land acknowledgement. That is such a powerful statement about the presence in past and present of Indigenous peoples in place. There's a spiritual context to that, and spiritual values permeate. When we're talking about what the outer boundaries are of human conduct with respect to the natural world, animals, plants, the relationships among peoples, there is a spiritual content to that, and that is not religion. That is, in essence, an ethical context for the law. You know where you find that? You find that in Indigenous customary law, set down at the time of origin and manifested over time. Indigenous peoples have institutions, they have laws, and they have cultural sovereignty, that volition that has enabled them to survive generation after generation. To bring that into the discourse, national, international, and local, indigenize the law. That's the power of that social movement. Thank you.
Thank you. I really appreciate the idea of focusing on the ethical context of law, and I think it's a great kind of segue into the discussion portion of our panel this morning, and it really focuses my attention on problematizing the meaning of law itself and the meaning of institutions, where law comes from, and what kind of moral power it has based on that foundation and its origins. And I guess just sort of thinking about some of the cross-cutting ideas that have come out of this really dynamic conversation, sort of starting with Shaun focusing us on introducing movements into legal education, focusing attention on different types of lawyers and their contributions across different kinds of domains within the profession. Purvi really orienting us around the need to think about movement lawyering in the moment, reckoning with white supremacy, dealing with what she very aptly termed the rupture, and how to think about moving forward against the backdrop of that rupture. And then Rebecca really focusing us on, again, the sort of moral and political rights of Indigenous people, and how to derive meaning and inspiration and political, I think, political vision from that in ways that can really guide us in terms of going forward. So I wanted just to start by asking you, and thinking, I guess, maybe about jumping off from some of Purvi's comments to think about pathways toward progress, and really what we mean when we talk about institutional reform. And I guess I wanted just to ask you about your view of scale, because we've sort of talked about institutional reform at multiple scales, right? The local, the international, the national. And I guess I'd like to invite you to kind of reflect on when we think about how lawyers and the law should relate to social movements. Is there a place to start, right? Is there a kind of level to start at, and how should we think about that level as a sort of jumping off point to broader reform? And then I guess I'll fold into that question about scale just a question about what we mean by social movements. And so these are very complicated formations. As we've talked about, not everyone has the same ideas about what the North Star is, even within a particular movement, or how to strategically move forward, which is always a complicated question. And so as we think about institutional reform, the appropriate location, I'd also just like to hear from all of you about how you think about using law, not just to expand the we, as Purvi so aptly said, but to really bridge division within movements themselves. So scale question, and then a question about how we should be thinking about social movements and building and strengthening them against the backdrop of complicated inter-movement relationships.
I mean, I can kick us off with some thoughts, because I think those are kind of the pressing questions for us. So I think at scale, you know, I'm really, I feel like it's, again, this ability to kind of do multiple things at once. So I feel like for movement lawyers, I think you really have to start at the local level. When we think about democracy, or we think about self-determination, or we think about reimagining systems, I think there's a unit at which, like, being very rooted in local communities is important, because otherwise these tend to be like fairly abstract conversations, or alternately, they're really oriented around a single policy or a single campaign or a single fight. And so I really feel like it's important for lawyers to really get grounded in the communities that they're in, because all of this at some point like plays out very aptly on the local level. So I think thinking about scale as not just sort of being in the world of ideas, but in the world of material shifts to people's lives. And I think at some level, if you're trying to impact, you know, reduce exploitation, reduce the amount of people who are, you know, losing their jobs or being evicted or being incarcerated. I think you have to think to some extent about a very practical, you know, what's happening in the communities that you're in. Also think for a lot of lawyers, there's this sort of celebration of, like, you know, like big moments and wanting to be involved in some big moment that's not in the community that you're in, right? If it was Ferguson, or if it was some other moment. And I think it's really powerful for people to realize that all these fights are happening in your own communities, and the questions of power and building movements that can actually be intersectional are relevant at the very local level. So whether, you know, it's like you were saying about the labor fights, and whether you can stitch together day laborers with domestic workers, and you know, you can take it at any sort of, you can take it at any level of scale. But I think that the second thing that has been brought up by a few people, this idea of the internationalizing of our perspective feels really important. And so thinking about, you know, when we think about, if we're trying to look at large systems that move, you know, the phenomenons of right-wing of neo-fascism, you know, of white supremacy, of corporate, you know, the sort of capital, like that is all moving at a global scale. And what we're seeing in our country is not sort of disconnected from what is happening, and particularly as Rebecca put so aptly, right, this question of Indigenous people and the origins of a lot of our modern democracies, like what is missing from that. So I think to me it's about like being rooted in local fights, but shifting our vantage point to be one that's more internationalist would be really important. I think in terms of this building and strengthening movements, right? I think lawyers, we actually have like a craft that can actually help to do a range of things. It's a versatile tool. You can do defensive work. You can do offensive work, try to win policies, or through like impact litigation, try to change policies. And then you can also work with communities that are trying to build alternatives. So I feel like in this question of building and strengthening, I think by us being really rooted in actual movements and how people are trying to collectivize problems versus being oriented by a lens of issue, or like I'm a direct services lawyer, or I'm an impact lawyer. I think by virtue of changing our central organizing principle to be one of what is actually collectivizing people and problems, I think that is where we start to do this work of building and strengthening, because people, legal services can be the kind of thing that draw people to a community meeting, right? Like communities get together and they want to advocate for a particular policy, and that happens at the local level. Lawyers can be useful in that too. So I mean, I think none of that is sort of a surprise to everyone, but I think this idea of shifting what it is that we're actually trying to achieve and our vantage point, I think will oftentimes make our work, no matter where we're situated, more impactful and more connected to this necessary thing of building the power, particularly of working class, people of color, Indigenous folks, like really people most proximate to the harms of the system.
Thank you. Shaun or Rebecca, did you have anything to add?
I think that Purvi made some beautiful comments, and I just respectfully wanted to respond also to part of what Shaun, you presented this morning in the context of this question, because I thought that you set forth many important ideas. But legal education and lawyering are powerfully interlinked, and it has been a concern of mine for many years that we cordon off the study of Indigenous peoples within law school to federal Indian law. If you have a school that teaches it, great. A lot of schools don't teach it. When people teach Johnson v. McIntosh and property, a lot of people don't even mention, too much about Indigenous people because it just seems like too hard. When a student asks about why does it say Indian tribes in the Commerce Clause, some people say, well, take Indian law. I'm not quite sure how that got in there, or what it means. And that frankly has to be unacceptable. If you have 567 federally recognized tribes in the United States with governments and court systems, teach about it in the first year. Don't leave it for some other thing. I mean, that's not an add-on. Those are governments within the United States. So I just wanted to say that.
So I would say a couple things that I think that respond to the question you raised, Scott, and some of Purvi and Rebecca's comments, at least in how I think about social movements. I kind of think about them generally as just kind of collectives of people and institutions working toward a particular set of socio and political goals. And in terms of how to strengthen social movements, I mean, a couple of things come to mind. One, focusing on commonalities and intersectionality, whether we're talking about racial, economic, or gender justice, and what it means for particular groups. I think about within that, being transparent about who are the most marginalized groups within those movements. And it makes me think about kind of, Derek Bell's comment about kind of looking to the bottom. I think about resource sharing. And within that is human resources, and how, law students and lawyers can make themselves available to social movements. And if that makes me think about Purvi's comments around power and empowering communities. And then to kind of just loop it back and bring it to the comments Rebecca just offered, how we're training our law students. Like, are we appropriately training our law students when we leave out issues tied to Indigenous peoples, when we don't talk about immigration law, when we don't talk about when we cordon off something like healthcare and health law, which constitutes 20% of our GDP. And so I think part of it is about thinking around how we engage legal education and what we teach specifically.
Thank you. You brought up.
I wanted to add one more thing to that. I think when we think about scale, we also think about what are the mass of lawyers doing, right? It's like the ABA says 97% of lawyers work, work basically either to protect the status quo, corporations, the powerful, right? Only 3% of Americans, 1.3 million lawyers, work on issues of justice and poverty. So it's like we're not just sort of agnostic bystanders to these questions. The vast majority of our profession is supporting those that are exploiting or marginalizing or incarcerating. So I think that the scale question has to be turned back around to us. As people, if law is a system that is intertwined with everybody's lives, and it's a thing that social movements can't evade, right? Like either you're being repressed, surveilled, harassed, right? Our movements are not. It is like they're actively being criminalized in many ways, right? That's the history. That's the current history, and so I think that question of scale has to be turned around back to us. What is it going to take for our profession to take a different moral position, to have a different set of ethics, to have a different social responsibility? And I think these questions that Shaun is really raising, and Rebecca and Scott, your work, right? Like, how do we change what is it that we think is the role of a lawyer in society? Because right now we're primarily protecting the way the world works. We're not, and in fact, we're perfecting these systems.
I think that's such an essential point. And in that regard, I do think that we are at another moment of potential rupture around how to think about the role of lawyers in promoting justice more broadly, bringing it back to the Trump lawyers and the election lawsuits and the broader legal mobilization to really undo the election and to unleash the white supremacist attacks that culminated in the Capitol insurrection. I have been both horrified by how disconnected those particular lawyers are from basic norms of engagement with respect to the democratic system and professional ethics. But I've also been heartened by the degree to which the public has mobilized against them and really taken a more active role in demanding more from lawyers more broadly. And so I think, again, building on Purvi and Shaun's excellent comments on this, it is a moment to not just rethink how movements could impact law and impose more dramatic and transformative institutional reform, but how to actually transform the profession itself, sort of using the lever of this particular moment in the backlash against egregious conduct of lawyers to really reimagine access to justice in a real way, in a way that does connect with the real needs of people on the ground. If I could just use that as a segue, because one of the comments that Rebecca made sort of puts me in the mind of back to the Lonnie Guinier and Gerald Torres article about social movements. The point that they make in that article is just the importance of, again, transcending limited legal reform and really thinking about how law could be mobilized in connection with movements to transform culture. And I did want to ask you all, in this environment, where people don't occupy the same normative and discursive space anymore, right? Where 70% of Republicans believe the election was unfair and that there's sort of a mainstreaming of this conspiracy theory. If you think about one aspect of the civil rights movement theory of change, it was to make normative arguments in the public domain that would persuade other people of the justice of the cause. And I just wanted you guys to reflect a little bit on how we can think about that theory of change now in light of denialism, in light of alternative facts, and in light of conspiracism, right? And specifically how we as lawyers and legal academics and law students who are trained in argument and thinking about how to make arguments that persuade can actually do that effectively in a context in which people don't agree on basic facts.
Professor Cummings, I think that's an extraordinarily important question, and I'm not sure that I have a great response to it, but in my work, one of the things that I run into continuously is that there's a lack of any foundation for the facts of what we're talking about. So if you thought about tribal land rights, tribal water rights, people have no idea where they come from, why they exist, if you should think about them in a stream adjudication, if treaties are a relic of the past, if they have any continuing presence. And you saw that over the summer with the McGirt case, when the McGirt case was released from the United States Supreme Court upholding the treaty right of the Muskogee Creek people from the 19th century. And then there was a huge outcry. And of course, that got into the energy resources community, and the ripple effects of that are happening. I could give you 7 different venues in which the ripple effects of McGirt are happening, but the continual questioning and those questions that you asked at the beginning, Purvi, the how and the why, and that is the matrix that we have to be sure that we are engaging responsibly. My personal view is that a public land grant institution like the University of Arizona, like UCLA, has a powerful role to play. So I'm actually formulating a project right now to get facts out about land, about water, and make it intercultural, intertribal and intercultural, because even the tribes themselves get pitted against each other in the wars over economic revenue from mining, or the harms that arose in the context of the closure of NGS. So we can't oversimplify things. There isn't one unitary Indigenous rights movement. There is a movement for justice, and that looks many different ways depending on the contextual part of that. So that's what I'm committed to.
Thank you. Purvi or Shaun, any comments or thoughts?
I mean, I could add a couple. I think one, I don't think lawyers are generally going to be the best narrative strategists. I think we have a lot of things that hamper our ability to, I think, be the best messengers for people about what's possible. I think even no matter how radical you are as a lawyer, I think years of being in this profession can change your paradigms. And so I think in many ways, I think about what we can speak truth about and how we can make space and elbow room for different messengers to speak with, I think, the kind of the capacity that can capture the sort of hearts and minds of people. So one, I think we have to speak more truth about race and class. I think that we oftentimes talk in sort of more politically neutered or, terms, or we discuss things about, the systems that I think speaking truth about getting to the heart of sort of what are the underpinnings of some of the systems, what is the system trying to protect? I think the more and more that we can speak about that, I actually think that resonates with folks. And I think, so one, I think it's about us bringing a different level of preciseness of language. And I think there's so many amazing movement lawyers across the ecosystem that are doing this brilliantly. And I think that brings me to the second point, which is, look, whether we like it or not, we have a certain kind of cultural power and legitimacy in society. And most of the time we like it. And so I think how we think about leveraging that power in a way that continues to extend our support for visionary movements made up of people who are oftentimes, in great danger for the positions that they hold, right? So I think how can we flank these different movement visionaries or or, you know, not to sort of celebrate a single person, but the sort of ideas that are coming out of our movements. So I feel like that's one thing we could be doing. I think third, look, I think we're going to have to become a more politicized force. We have this false neutrality that we are programmed into. We tend to want to shy away from taking very particular political stances. I think in different parts of the world, lawyers have become politicized forces themselves. They've protested altogether in Pakistan. They have called out the system when the system is actually imploding. And so I think for us to sort of take more political risk ourselves, go to the protests, like do more than just lawyer. I think that's going to be part of our work. That's going to be able to change the way, not just the words we say, but like how our presence in society changes a sense of what's normal. And we saw lawyers do that in different ways and in different degrees during this last election cycle. And then I think the last thing is you just got to win material like value for marginalized communities. I think ultimately we can have a lot of conjecture, disinformation, lack of like facts are not real, but what people know and what is real is what is happening in their lives. And so the more we get into the fights that are addressing the people that are hurting the most, or we're working on pushing back on evictions while we're trying to win cancel the rent, like when we actually engage in the tactical part of the fights where we're trying to turn these ideas into reality, I think we become a muscle in the back, you know, a sort of, we work at the back of movements in a way where our value, you know, movements themselves actually become, you know, truth tellers by what they're exposing and what they're winning. So those are some thoughts.
Great, thank you. Shaun, do you have any final thoughts about this before we open it up to audience questions?
Yeah, I think much of what I'd say is kind of subject to the stipulations that Purvi offered in terms of the kind of limitations of what the legal profession can offer as a vehicle for the mainstream public. But I'd say a couple of things. I think the first might be for lawyers, legal commentators to simplify their messages and make arguments anyway. I think the reality is that some people are going to be persuaded, you know, by reason and some won't. And so that feels like an unalterable fact. I think a lot about kind of civic legal education. You know, some people, you know, have very underdeveloped understandings of the legal systems or a comprehension of the legal system that's outright wrong. And I think there's a way for lawyers, the legal professoriate, legal commentators to help the mainstream public better understand our legal system. And I think a third, and one that doesn't get talked about enough, is the kind of the role of legal punditry. And so when you think about a lot of the kind of mainstream legal voices, it's fairly homogenous and oftentimes in service of or defenders of the status quo that many social movements are working against. And I think this is slowly changing with social media now that more diverse legal professionals are having a voice to the mainstream public. But I do think that there's a way that the kind of mainstream legal punditry contributes to the ways that people understand law and understand our legal system. And so all those things kind of put together make me think about the ways that lawyers can better help educate the mainstream public about our legal system. But again, at the end of the day, I think that there's just ultimately a limitation to what lawyers can do because of the ways that they are trained and conditioned, which again brings me back to the initial point around the importance of legal education.
And that I think is a great point to kind of segue into the audience questions. We have a couple here that I'd like to present to the panelists. And the first one I think jumps off directly from the point that was just made. And so I'm gonna restate the question so that everyone can hear and read in the ASL translation. So I'll begin. The question goes, I'd be interested to hear perspectives on how the current infrastructure and financing of public interest law in law schools impacts the funneling of students to positions that perpetuate the status quo, as Purvi just discussed. I know numerous law students, including myself, who have struggled mightily to find paying public interest positions in their communities, and not just in New York, DC, and San Francisco. How does our nonprofit model, where the great majority of jobs seem to be in development, and the fellowship model of public interest lawyering, where you have to be exceptional and come up with a new and exciting project instead of just serving the needs that a community embedded organization has already identified, need to change? So that's a great question, and really speaks to the themes of legal education and access to justice, and how to really build legal power that can complement local movement power. Shaun, maybe if we could start with you, if you have thoughts about that, since it sort of really does bridge your core comments and research.
Yeah, so I'd say a couple of things. I think the first is tied to, the kinds of things that legal education tends to promote in terms of what is considered to be an ideal professional trajectory. I mean, I think the reality is that a lot of schools, people are incentivized into going into big law. I think, for many people, I think that's fine. I worked in big law, also worked in public interest. But I think schools somewhat incentivize students into and nudge students toward working in big law. And I think UCLA and my alma mater, Berkeley, are probably better about that than many other law schools, but that's still a problem. But I mean, to the question of financing, it's something that I've thought about a lot. And the federal government, I think there's a role for the federal government and state governments in the context of funding public interest law. And so if you look at something like, the Legal Services Corporation, which funds a segment of civil legal aid, they only get around $300 to $350 million a year to support civil legal aid for the country. That's peanuts. And so I think there's a way, and I think part of the problem is people don't have the best understanding of what civil legal aid attorneys do. So it ends up not being an issue that politicians are forced to have a political platform around or meaningfully fund. So I think that there's that example. And I think about, one of the things I write about is this program that existed from about, I think, 1967 to 1984, called the Reginald Heber Smith Community Fellowship Program. The people were called Reggies. And essentially it was Teach for America for poverty lawyers. It was came out of the War on Poverty, funded by the federal government, and they would support law students to do 2 years of work at a public interest organization. The program ran for 17, 18 years, was ended by the Reagan administration, which has its own troublesome connection to public interest law, particularly in California. And interestingly, it was the ending of the Reggie program that in part created a void for programs like the Skadden Fellowship, Equal Justice Works, that developed in the 90s and thereafter. And so part of this financing question is about, creating a role for the federal government to support public interest work, because it's grossly underfunded on the civil side and on the criminal side. But I think part of that is making it a legislative issue, and something that people care about, and that requires lawyers to give the general public a better understanding of the important work that these attorneys do, whether it's helping people get public benefits, helping people get health care, unemployment compensation, helping people in the context of family law and domestic violence, and in the criminal context in terms of keeping people out of jail, and having more effective ways of addressing criminal conduct. And so that's the thing that stands out to me the most, is thinking about the ways the federal government could better support public interest law.
That's fantastic. If I might just jump in to add a couple of thoughts on this point. One is just to build on your point about funding and connect it back to our discussion about scale. One of the I think one of the interesting social movement dimensions of the right to counsel movement more broadly has been kind of the intersection between the housing justice movement and right to counsel movement in cities like LA and San Francisco and New York that have really been pretty successful in creating opportunities for establishing local rights to counsel in eviction court and some other types of legal arenas that have created other opportunities, I think, for leveraging resources and maybe trying to scale up from these local victories into sort of broader statewide right to counsel efforts that can create more funding. And the other thing in response to the question is just two small points. One is, there are pathways from non-public interest jobs into public interest jobs. And one of the things that we've learned from studying students from UCLA that have gone into public interest work is that a significant portion of them actually don't start out there, but end up there over time because of the sort of widening opportunity structure that happens once you gain more experience. And so I think there is sort of short-term and long-term dimensions to it. And then there's also a network of firms in the private sector that do amazing public interest work because they're litigating in relationship to police violence cases and civil rights cases and providing other sorts of support to the labor movement and affordable housing developers that are other spaces to potentially really invest in as an opportunity for public interest work over time.
Yeah, I wanted to add a couple of thoughts here. I mean, and I feel like, I'm just going to keep it 1,000 because I feel like we need to just be real. Like the vast majority of jobs that we can get as lawyers are not seeking to disrupt powers, are not actually trying to transform systems. And so I feel like this contradiction that I've heard a lot of young people that are emerging or people that are new to the law that are trying to take on this role of a lawyer that's committed to social changes, it is a contradiction. Like the existing institutions, the way our systems are set up, they don't actually value, philanthropy doesn't value, our law schools don't value for the most part, this kind of work, right? And so ultimately, to me, I think the question is like, that is a problem. And then the nonprofit, I'm a 3-time founder of nonprofits. They're flawed, but they are what we have currently. And more people are imagining new types of organizations and new ways of structuring our finances and new financial models. And I think all of that is really important. But to the folks that are listening, I think it's being super clear. The reason why you're struggling to make a living doing something like this is because that is not what our profession is intended to do. And the more you can understand the political reasons for that, right? When we had the emergence of all of our legacy civil rights organizations that came 50 plus years ago, that was out of the civil rights movement and the Black freedom movement in the South. It created a whole new generation of legal organizations. And over time, we've seen, that both be an opportunity and at times be a challenge, right? As those institutions have grown bigger and bigger. I think for those of us that were really intent on building new institutions that are movement lawyering oriented, we've had, over the last 6 years, different moments that have created an impetus. I think the truth also about civil legal aid is that it's politicized, right? While that originally started as a radical concept of lawyers rooted in every community that were going to address the material needs of people, like systematically over time, they have been neutered and restricted and under-resourced. So to me, it's like understanding your role as not separate from the broader politics that are the very thing that we're trying to impact. So what do we do with that reality? I think that you are going to have, we have to have these conversations and build a new paradigm for what do legal organizations look like in the 21st century. For me, I believe movement lawyering organizations that have a sort of radical politic in their DNA are incredibly important. We should have one in every city in America. And philanthropy, part of the work that I do at Movement Law Lab is trying to get people to understand this isn't just about a woke way of lawyering. It's actually building the critical infrastructure into our communities so that we can exercise little democracy and big D democracy. And so I think we're going to have to take on some of these fights, right? And we're going to have to redefine for sort of the way money flows into nonprofits. We're going to have to say this is actually a vision for what liberatory lawyering can look like, and not over dumping money into the big national organizations that do impact litigation. So I think we have to kind of take on some of these big conversations. And I also think, like, for young folks that are watching this, like, we're going to need you to come up with new financial models and new creative ways to build independence from nonprofit structures. And, there's been a lot of different talk about mutual aids and, and some of that, like, I've worked in nonprofits. I think they can be leveraged, and they're an important part of the ecosystem to sort of challenge the status quo, but they're imperfect. So I also think that's where this idea of, like, nuance, like, how do you understand the limitations of the institution you're working in while you're simultaneously leveraging it to the full capacity possible. So I would say it's the two things: build new institutions with new values, new politics, new financial models, and get inside institutions that are limited and imperfect and agitate for them to do what is originally in their mission and in our charge and in our history and lineage as public interest lawyers.
Thank you. I'm mindful of the time, and there is one other question in the chat that I think would kind of bridge this discussion in our discussion of Indigenous rights, and maybe we can pose to Rebecca here. And so I'm going to read the question. There is an emerging tension with the turn to Indigenous people's rights and experience as a model for transformative change, which I'll state this way: the nuanced but substantive difference between collective. It just got taken away. There it is. So it just popped out of the screen and now it's back. So the emerging tension, I'll state this way: the nuanced but substantive difference between collective and political rights of Indigenous peoples to land and self-determination, and the demand for democratic participation and local autonomy. Non-Indigenous communities in the latter space, for example, in Latin America, using the discourse of Indigenous rights, right to consultation, and some measure of local autonomy, in practices, resistance camps to extractivist industries. Just wanted to comment that we need more work around these nuances, and non-Indigenous movement lawyers need to be sensitive, respectful, and deferential to leaders in the Indigenous rights movement, and be educated on the struggle for Indigenous rights, and careful not to appropriate and or dilute the framework of Indigenous people's rights. So thank you for that question.
That is a wonderful question. Absolutely great question. You can make a 2-hour lecture on that question. So I'm just going to hit maybe 3 themes within that to think about. So back to Professor Cummings' comment about looking at domestic and then international to see, what's aligning. At the international level, of course, the Brotherhood of Nations that existed back in the Doctrine of Discovery is still together, and they're an economic bloc. And if you look at things like, patent law and technology transfer and climate change adaptation, if you look at all of that, the power is still where it was back when. So, of course, the marginalized nations that suffered under colonial law they're now nation states, but they're worried about that. So they have actually piggybacked on Indigenous rights in some cases, saying, well, our whole country is Indigenous, and therefore we have X, Y, or Z distinctive rights as opposed to these, larger attempts to disenfranchise among the corporate, world with the nation states backing them. That also marginalizes Indigenous peoples in those countries because they don't have a way to effectively retain their territorial rights. So if all of the resources belong to the country, and then the country can decide whether to mine or do whatever, what happens to the land-based communities? So the second movement is this idea to conflate Indigenous peoples with local communities, trying to keep that attachment to territory, but In a sense, you take the Indigenous out of it and you say it's that attachment to territory that we care about in an ethical frame, right? That's a moral context that is differentiated and we need to give rights. So if you look at La Via Campesina, food sovereignty, that's the level, water, that's the level in which they're interrogating it. Now, again, it's not in great alignment with Indigenous rights. So the right of self-determination as peoples is powerfully invoked by the Covenant on Civil and Political Rights. It's the backbone of the UN human rights structure. Indigenous peoples were taken out of that. The UN Declaration on the Rights of Indigenous Peoples said that that was an injustice and you need to put that back into it. If you look at Indigenous peoples and how they're organized, it's not a one-size-fits-all model. And there is a lot of room for appreciation and respect for the distinctive nature, but also the possibility to learning. And here I'll compliment again some of my colleagues on the ASU faculty, Randall Akey, for example. So he's working with Maori leaders and others to basically get into that structure of intellectual property rights in a way that reflects Indigenous values. And when you go to those group meetings where Maori people and Indigenous people from Australia and Canada are represented with the different tribal nations here and Native Hawaiian people, that is one of the most rich and profound experiences that I've ever had. And it's because of indigeneity. So there is no compromise to Indigenous rights. It's distinctive, it deserves respect, and yes, we should not conflate those categories, but we still have to have sympathy and understanding for why they're being mobilized by other social movements in other countries.
So thank you so much. I think drawing attention to the ideas of sympathy, respect within and across movements, and how we as lawyers must sort of use the platform of this sympathy and respect as a foundation for our effort to support the transformative and emancipatory thinking of social movements is a just wonderful place for us to stop. And I want to just say how much I appreciate and how grateful I am to all of you for this really rich and inspirational conversation. I really appreciate both the kind of critical insights and contributions and really urging to sort of think in ways that are challenging to the conventional framework, but also giving us a sense of hope and vision. I think those two things must go together in this moment and beyond. And you guys just really, I think, mesh those in ways that feel really galvanizing and engaging. So thank you so much. We're just enormously grateful for your contributions. I want to say thank you for all of you for your attention and contributions with the questions. We are going to stop the panel now, and there will be a 30-minute break. I just want to remind you all to return at 12:30 when Professor Sunita Patel will moderate the closing conversation on social movements, freedom dreams, and the law, featuring Robin D.G. Kelley, Marbre Stahly-Butts, Jacinta Gonzalez, and Dean Spade. So thank you very much. This was terrific, and we look forward to another great conversation this afternoon. Thank you.
Hello, everyone. Thank you for coming back and joining us. We're happy to welcome you all back to our second panel of day 2 of the UCLA Law Review's 2021 Symposium, Structural Inequality and the Law. Again, I'm Ryan Garcia. I'm the UCLA Law Review Symposium editor. I just want to address a few formatting details first. You'll see this posted in the chat. We will have 2 American Sign Language interpreters rotating during the sessions, and they will appear automatically alongside the speakers. During the webinar, for closed captioning, please click the CC icon at the bottom of the Zoom toolbar. I would now like to take a moment to introduce our faculty sponsor, Professor Sunita Patel, who will be moderating our final panel and closing conversation, Social Movements, Freedom Dreams, and the Law. Professor Patel is an assistant professor of law here at UCLA School of Law. She is also the faculty director of the UCLA Veterans Legal Clinic. Professor Patel, thank you for joining us today.
It's great to see everyone. I really wish we were all in the room together so we could be in community, and that's with everyone in the audience as well. So thank you everyone for joining us from around the globe, and we are just so delighted to have everyone here for this really engaging and lively closing panel. So I want to welcome everyone to the final contribution to our 2-day virtual symposium. My job here is to mostly stay out of the way. I'm going to give a minute or two of framing, and very briefly introduce our speakers and pivot to some opening invitations for discussion. So I'm joined here today by Marbre Stahly-Butts, a member of the leadership team of the Movement for Black Lives Policy Table. I've had the great privilege of working with Marbre on policing issues in New York City in like a different lifetime ago. So thank you for being here. Jacinta Gonzalez, also the senior campaign organizer with Mi Gente, who I've also had the great pleasure of working with, and I'm so glad you're here. Dean Spade, Associate Professor of Seattle University School of Law. Thanks, Dean. And also Robin D.G. Kelley, the Gary B. Nash Endowed Chair in U.S. History at UCLA Law. He is really the inspiration behind this, this closing conversation. So in the spirit of a collective decision not to do lengthy bios, I urge you to read more about the incredible backgrounds of everyone here in the program booklet, which is linked in the chat. So the goal of this discussion is to move us into a grounded conversation that is conscious of the practical ideas of where do we go from here. You know, we've had these 2 days of conversations, we've had 3 amazing panels, everything from the insurrection at the Capitol, thinking about civil legal services, thinking about movement lawyering, critical race theory, and feminism. And so now we're going to round this out and think a little bit more about abolition, mutual aid, the limits of the law as a tool, and the historical context in which we sit. Then we're going to go into a little deeper into the role of lawyers and law students and how to rebuild differently. So Marbre, I'm going to start with you. And I want you to tell us a little bit about the work of Law for Black Lives and why you have called on legal advocates to consider the urgency of abolition and what it means beyond just shrinking the footprint of carcerality. And also, I hope that you can ground us in the tradition and legacy of your vision. And so what I mean by that is that I know you have a deep commitment to Black history, and while abolition is gaining popular attention today, it isn't a new framework. Black feminists and grassroots activists, you know, Ruthie Gilmore, Andrea Ritchie, so many others have been telling us to defund and abolish the police for a long time, and also build, you know, different institutions to meet the needs of our communities. So I ask that you help ground us, Marbre, as we start a conversation to rethink the tomorrow that we want, while conscious of the many seeds of yesterdays from which the current movement grows. So thank you. Take it away.
Absolutely. So first of all, thank you so much. I pretty much fangirl everyone on this panel. So I feel incredibly blessed and honored to be in conversation and humbled by it. So, and abolition, my grandma was a preacher, and I swear we'd go any place and she would want you to find Christ. And I feel that way about abolition. Well, I'm just like the prophetio. I'm like, let's talk about it. Like, let me make you an abolitionist. So I'm really excited. I have to say that when I was in law school, the possibility of a conversation about abolition inside of kind of law school spaces was impossible. And so I think it really is the power of movement, of the incredible thinkers you named who have made this conversation possible. So I'm super grateful. So I'm going to try in 7 minutes, and someone should cut me off. That's a real thing. Like, please give me the hand signals. To both talk about kind of my own, I think, commitment to abolition and why I think it's so essential in conversations around structural inequality and change, and the unique challenges of lawyers and law students in adopting an abolitionist frame, but also the unique, I think, necessity of it. So I'm going to start by just saying that I think any symposium about structural change has to include a conversation around abolition and what it means. And when I say abolition, I mean of the prison industrial complex specifically, and we define that, and this is critical resistance's definition, which everyone should Google. They are an amazing luminary around abolition and have been for decades now. But the PIC is defined as kind of the overlapping interests of government and industry that use surveillance, policing, imprisonment as solutions to economic, social, and political problems. And the PIC really interacts with Black people specifically, but with all of us on almost every kind of sphere of our existence. And so it is enshrined in our Constitution via the 13th Amendment, in which kind of structural inequality is structured through differential rights and ability to exercise rights via kind of the use of criminalization to deny people their rights. But it also is in kind of every criminal statute, every regulatory statute, every kind of cultural way that we interact with each other, that if you have a criminal record, you are excluded from, barred from, restricted from employment opportunities, housing, even access to your own children, often licenses, healthcare, education, like you name it. And so the PIC really does structure every single component of our society. And so when we say kind of unequal structures, it's essential that we think about how the prison industrial complex is part of that restructuring. And, you know, although I think the PIC is the focus of my talk today and my kind of my own thinking, I think there's a lot that connects the PIC and abolition to kind of democratic abolition as well. And so the work of folks like Du Bois and Angela Davis to think about what is kind of abolition in the democratic sense as well, and how does kind of the legacy of slavery, of the institutions that were built to maintain slavery, to maintain white supremacy in the most literal fashion. And so the Senate, the Electoral College, these are institutions that were created to assure that slaveholders in the South could maintain their power despite the kind of challenges of population. And so I think that it's important to connect those two, that there really is a long legacy of thinking about abolition, both as of the PIC, but also how it connects democratic institutions. And I think we'll revisit this in talking about reparations, that by building up kind of a new post-slavery society without addressing these root institutions that actually like manifest and perpetuate slavery, we were destined to recreate it in some ways and senses. And so I think that I have come to believe, after kind of much study, after my own personal experiences, after seeing the society that we live in, that reform of the prison industrial complex is impossible. That there's no way to make kind of tweaks or changes inside these systems that actually cure or address the full range of issues of inhumanities inside of them. That what is necessary is an abolition of these systems. And I'm going to kind of give my 5 reasons why I think that is true. There are a lot of folks who have written on this and talked about this in really beautiful ways that y'all should check out. And I'll name a few of those folks. But I think that for me, and this is not, although this is kind of a radical idea, I think it's less radical now than it was last summer. But the reality is that this idea of like immediate abolition, that we have to move towards an abolition of these systems in 1860 was just as radical. When folks said, actually, I think we have to end slavery today, most of society was like, nah, slow down. Like, what's the slower, more incremental way of doing that? And so this refusal, I think, in this hesitancy to embrace abolition is not new. We saw it before, I think, the Civil War. We saw it throughout the last kind of hundreds of years in this country. And so I want to just name that I really do see the fight for abolition, the prison industrial complex, as a continuation of the fight for abolition of slavery, which I think is an unfinished business in many ways. But the hesitancy, the reasons given for why we can't just do that are the same ones that are recycled, I think, from that era as well. I'll also say that I think in the history of Black folks specifically, but not only, that the idea of incremental reform has always failed us. That over and over again in our history, the leaning towards the embrace of kind of small incremental reforms, neoliberalism reforms, has again and again failed Black communities in this country and often made them then the villains of those failures. And so I want to name that I think it's from that history that I really believe and in the necessity of abolition as the answer to many of the issues that we're facing. So I think those 5 key reasons for me why I think we should embrace abolition. One is history, and I think I've touched on this a bit, but really I think the fight for the end of the prison industrial complex is really a fight for the afterlife of slavery. And this I think is a term that today Hartman often uses, that we see the afterlives with an S of slavery inside of the prison industrial complex and inside of these systems. And that the origins of these systems really are in chattel slavery, that the organization of these relationships began in chattel slavery, and criminalization and mass incarceration really was a solution, an answer given to the end of slavery to maintain social relationships and racial hierarchies. And so I think we have to understand that these systems are not misplaced, they're not like oopsie-daisy, they're racist, they are inherently at the root created to control social relationships in such a way and to racialize them. And so I think that's really important, that I think that these systems are not, we often say like broken or failing. They are not either of those things. These systems were created to do exactly what they were doing, from the prison industrial complex to the policing system, to the education system, to the child welfare system. These were created to racialize in deep ways and to indoctrinate. And so I think we just have to acknowledge that there's not a failure of systems, and there's really a success of them. And that is what we're kind of living and reaping. And so to me, this history of the prison industrial complex, like rooted deeply in chattel slavery, really demands an abolition and like a derooting and unrooting of them. So that's one. History is reason number 1 for abolition. Number 2, I think, is just racism, that these systems are inherently racist, that they were meant to be racist, they were structured for racialized goals, that there was no way to separate racialization from these systems, and therefore we have to throw out the systems as well. And again, it's not incidental that they're racialized, that from the beginning we see kind of the onset of the use of criminalization in the post-Civil War era, in the Black codes, in convict leasing. We can trace that history through Jim Crow, through kind of the post-civil rights era to today in the era of mass incarceration, that these really are through lines, and there's something very purposeful about these systems being racialized. It's not accidental in any way, shape, or form. And at every single juncture in this system, we know that Black folks and brown folks are over-criminalized, and so twice likely to be arrested, to be sentenced, all of that. And so we understand that we can't actually erase or untangle racism from the prison industrial complex. And then thirdly is classism, that as racism is also intertwined, so is classism, that we know that these systems also prey on surplus labor in real ways. We know that the annual average income of somebody who's been incarcerated is $18,000 a year, that we know folks who are put inside these systems, that they feed capitalistic intentions and machines. I think Ruthie Gilman talks a lot about this, but I think the reality is these systems serve both a racialization function and a capitalist function in terms of kind of labor. And then fourthly, and for me, this is the most important one, these systems are inhumane. I don't think that any human being belongs in a cage. I don't think that people are disposable. I don't think that the violence of the police state, of prisons, actually solves or corrects violence inside of our communities against women and GNC folks and queer folks. I don't think those are the solutions to our violence. And so I really do believe that at the heart of abolition is a deep belief in humanity and redemption, that we cannot dispose of people, we cannot cage people, we can't sanitize these systems that literally are deeply violent to the bodies of people every single day. And then lastly, these are ineffective systems. The prison industrial complex actually doesn't solve the aims it claims to solve. And so for instance, we know that there was absolutely no evidence, and literally, like, find me a study, I'll give you my email address, call me. There was no evidence that either policing or caging of people results in less crime. right? So I just want to say that there was no evidence. There was not a single study that conclusively finds that either policing or cages or incarceration reduces crime or harm. What we know does reduce crime and harm is real incomes. It's like paying people to do work, to have money in their pocket, to feed their children, and to have housing actually does reduce harmful incidences. And so just to name this whole kind of common sense that these systems are functioning is really, I think, the biggest lie that we have to reckon with, that there is no evidence that they function, that because we have not built anything else, we rely on them. But the reality is that they are not actually functioning systems of failures. I think that it's interesting that abolition at this moment is really being led by survivors who are often also criminalized. But if you ask most folks who have survived these systems, whether as people who have been incarcerated or as people who have been victimized, these systems fail them at every single turn. That, for instance, we know that less than half of murders go unsolved in many big cities. The numbers for rape and sexual assault are even lower, that these systems aren't actually addressing the harms they claim to address. And they are, in the meantime, enacting incredible violence against people all the time. And so I think that's really important to name and say. And we've invested literally millions, trillions of dollars over the last few decades in these systems. And as a result, we have built these systems to be the only solution to any kinds of harms. And so whether those are social harms, economic harms, we have said the carceral state is our solution to everything, to mental health illness, to poverty. We've criminalized poverty to ensure that that is the place where we also deal with that. And so I think it's important to name that we've invested so much into these systems where not only have they failed us, but by doing that, we haven't invested in the social safety net, in housing, in supportive services that actually would keep our people safe and would hold our people. And so this choice, this ethical choice to invest in systems of harm as opposed to systems that help us thrive, I think is it's a cycle where we kind of prove ourselves right at every turn, right? And I'll also say that, what these systems are effective in doing is in maintaining white supremacy, in maintaining heteropatriarchy, and suppression of revolutionary movements. And so we know that criminalization is used right now. We can look at Florida or other states across the country who are passing anti-protest bills, that criminalization is used to limit and to silence protests and movements across the country. We also know that the expanding surveillance state is limiting the ability of folks to organize in basic ways. And that really these systems are meant to maintain the status quo, and that is exactly what they do. So I think I'll just end on saying that abolition at its heart is as much about what we destroy or take apart as what we build. And I think that's really essential, that so much attention is paid to kind of what we have to defund and dismantle and delegitimize, and that is essential. We cannot maintain these systems of white supremacy, of the carceral state, and at the same time feed the needs and the infrastructures we have to build to keep our people safe. But abolition is as much about kind of the radical imagination of what actually is the world we can live in. We don't need prisons and jails. I think there's a really beautiful line. I don't know if it's Ruthie Gilmore or Miriam Kaba, who both are people who y'all should worship and Google and do other things too. But this line of abolition is about creating a world where prisons and jails aren't necessary. So it's not just about getting rid of them. And so how do we actually build a society of mutual aid, of mutual care, of love, of joy, of respect, where we don't actually need prisons and cages anymore. And so I think it's about, reordering social relationships and redistributing wealth in a way that actually feeds us and moves us in that direction. I think there's a unique mandate and question for lawyers and legal workers who are really the handmaidens of this system to think through how do we actually interrupt these cycles and delegitimize these systems in basic ways. And I know I'm over, so I'm going to stop. But that's my abolition.
Thank you. Thank you, Marbre. That was a great grounding, a great way to get us started. As part of, as you said, the other side of the coin of this conversation is around reimagining the world that we want to live in, and to be liberatory in our thinking, and really think expansively and not be confined by what we know today and what systems we have today. So one part of the puzzle is mutual aid and community support networks. As with abolition, mutual aid's a generations-long project, and certainly one that is more robust outside the legal academy than inside law schools and law. We know that the Black Panther Party, for example, developed a free breakfast program that was essential to their organizing platform. So I wanted to turn to Dean Spade, who just recently published, or maybe not that recently, but recently enough, published a book called Mutual Aid that I highly recommend. And I'll turn to him now. Can you talk more about the concept of mutual aid, its relevance to discussions of structural inequality, in the law, and the project of building and rebuilding. And in that context, I also invite you to talk about the role of experimentation and the way that the law and legal remedy always, often wants like the best thing in an immediate way, and then wants us to replicate that model over and over again.
Yeah, I'm so grateful to be part of this conversation. I mean, this is such an amazing panel of people and an amazing whole event. And yeah, this is such a juicy question that you're asking me. Starting my timer so that I try to stay on topic. And wonderful to follow that brilliant thinking about, I feel like the ground that was just laid about what abolition is and why reform doesn't work and why legal reforms have historically expanded systems that actually our communities need to dismantle is just really key, tied into what I'm thinking about too. I think when I think about these questions and the general topics of this conference, I'm thinking a lot about kind of the really intense crises that we're facing. Like, I feel like that's where I start, right? So obviously like the existential crisis of what's happening with the climate, the outrageous levels of wealth concentration that we are seeing, meaning outrageous levels of poverty that we're seeing domestically and globally, the ongoing crisis of having these criminalization and immigration enforcement systems devouring our communities, and like the COVID crisis, obviously, as like a very acute thing happening right now that is very much unevenly harming people in our society. And we're in this moment where we just moved from the Trump administration to the Biden administration. And I think a lot of us are facing the very plain reality that the Biden administration cannot meet any of these crises. And so it's up to us. And so what does that mean for us, right? To really notice that there's a danger in a moment like this of people being demobilized by the idea that the Democratic Party is going to come and return us to normal. And really thinking about what that normal is, that normal is this brutal system of extraction that has gotten us exactly where we are right now, where there is no wiggle room for us to wait around and hope that these people are going to do something better. And all the signals that the Biden administration is giving us by appointing all these oil and gas people and these arms dealers to these top positions. And then the really interesting demobilizing tactic they're using, which is appointing people like that who are also people of color or trans or queer or whatever, right? Like that's their move, that's one of their many demobilizing moves is this move of what I think of as just really inadequate and damaging reforms, including the reform of saying, let's put these kinds of faces in high places to operate the exact same agenda that's been operated over the course of the many presidencies in recent decades, and much of this all the way, back to the founding. So this is, one key tactic, one key sort of skill we need, of course, is to be able to actually have a clear analysis about what these demobilizing reforms are. Abolition is a central toolbox for us for that, and to really understand what's a surface change that is going to maintain the system as it is. The other thing that's like so essential at a moment of crisis like this, of course, is just people actually trying to help each other survive. And that's what that mutual aid piece is about, right? So mutual aid is when we do survival-centered work with each other that is based in a shared idea that the cause of the crisis is not the people in crisis, which is like what charities and nonprofits tend to focus on, but instead the cause is these generalized systems that are either creating and or worsening these crises. And so there's a kind of shared solidarity and analysis about where the problem is. And there's a deep focus on self-determination of people in crisis, and on the idea that the people who have the most wisdom about the crisis are people facing it, not like some elites from a nonprofit or a policy institute or whatever. So mutual aid work has been part of all powerful social movements. The kinds of mutual aid work I'm sure people are seeing today are things like COVID grocery delivery projects, people supporting people, unhoused people at encampments and helping them charge their phones and helping them bring food and tents, and also people defending those encampments from the police when the police are raiding them. This is happening all over the country, these beautiful defenses of people's encampments. People blocking housing court doors, right, to stop evictions and slow evictions, people blocking ICE arrests, people supporting people who've made really dangerous journeys through the desert to cross the border. Like all of this kind of direct work, supporting people inside prisons, all this like direct work to support people in the crises that have been produced. Obviously also disaster work, people helping people who are facing the fires and the smoke and the floods and the storms, who are left behind by FEMA's racist and inadequate structures. So mutual aid is really important because it helps us survive, but also it is the mechanism that builds large social movements. It's the way most people enter social movements, either because they need something and these people are providing it, and they're providing it in a way that's not stigmatizing, and then it's got a different idea about the causes, and then it swoops you into, oh, I could also be part of this big fight, and I might join these other bold tactics to fight that. And people also join because like they went through something like that before, and now they want to help people who are going through it, or they just care about people who are going through it. Like when people, and this is a beautiful thing about human nature, is like when people get angry and scared about what's happening, they want to help immediately. So most people enter movements not through some policy job, but through mutual aid projects, which are mostly volunteer based. And in mutual aid projects, we build these kind of new social relations that I think were just being talked about in the prior presentation, right? We actually practice like sharing with each other, making decisions together. When I think about Robin's work in the book Freedom Dreams, which had so much influence on me many years ago now, especially this idea that we can build power by breaking dependence on extractive systems and creating our own ways of doing food and energy and childcare and all of that. Like that's so powerful. And also why mutual aid is so threatening to governments, and why it tends to be criminalized as it becomes more and more bold and widespread. We can talk about that at any point. But so mutual aid is where we're actually practicing these new social relations, where we're getting together and saying like, we don't have to wait until the next election or until some nonprofit comes out with a report to solve our own problems. And we're practicing these skills of collective self-determination and shared governments. We're like, how do we all want to do this? Let's all have a say in it. And also we're all volunteers in this work. And so we're not going to like just wait for the ED to tell us how it's really done, or the person with the highest degree, or the man, or the white person, or whatever that story often is at any like social justice jobs we have. Mutual aid is also really significant because it's all about like care work and reproductive labor, which is usually women's work and the work of people of color, especially women of color in our society, and is dismissed, uncompensated, undercompensated, ignored. And actually it's the center of our lives. It's what makes anything possible. And so it really shifts our thinking around that. So I'll just finish by saying, I think we're in this really key moment of these crises. We're in a moment of potential intense mobilizations, building on the really huge mobilizations we've seen in the last year. And we're also in a moment where there's always the danger of demobilization, where they're like, oh, we've got this taken care of. We appointed this other person from this community and to be the police chief, so it'll be great, or whatever the story is, where they tell us our problems have already been solved. Oh, that's my timer. And these are truly dire conditions. I want to say, I think that most people are in denial about the climate crisis. I mean, and it is our responsibility to see that it's determining everything else that happens, and that we do not have time to wait for the right person to graduate from some elite school and solve it for us, or whatever that fantasy is in the sort of elite nonprofit world. So I'm so excited to be part of this conversation. I'll stop there.
Thank you so much. That was so generative. It reminded me, when you said the criminalization of mutual aid work, I mean, it just reminded me of like Food Not Bombs, which, was demonized and shut down. And that, I mean, I'm aging myself, I think, but let me turn now to Jacinta, who was joining us from Arizona, actually, kind of the belly of the beast when we think about border enforcement, immigration issues, but also such a space of renewal and hope in some ways. So thank you for being here. And I want to take us a step back a little bit and to build off of something Dean mentioned around the democratic platform and sort of what's happening now. And immigration is a space where, immigration reform is a space where we're going to see the potential for an Obama Biden 2.0, where we know there was, President Obama was called the deporter in chief. And that's not to take away anything from how regressive everything became in the last administration, but we need to be thinking beyond what did we have during the last Democratic administration. So I want to bring you into the conversation to think a little bit about the current political situation, and in particular, because Mi Gente is the political home for many Latinx community members. And one of the themes that we've been talking about in the symposium is the use of law or the limits of the use of law to solve social and democratic problems. So how movements have capaciously considered the tools of law, but also thought about are thinking about ways to build a different tomorrow. So I want to ask you to first talk about, in this first intervention, about immigration, policing, and surveillance. So what are the ways that Mi Gente is adopting an abolitionist ethic in the face of practically no positive law when we think about, or legal interventions when we think about immigration? So can you talk a little bit about that?
Sure. I mean, there's so many things to talk about, and also really excited to be part of this panel and to be sharing such amazing company. So yeah, thank you for the space to talk about some of these things. I mean, I think to me, there's two lenses which are two instances that are important to look at this particular moment in terms of how law is kind of helping shape what the immigrant rights movement is demanding. I think one, there's like a historic lens that we have to look at in terms of how our movements have dealt, for example, with deportation. You know, when I first started organizing undocumented workers in New Orleans post-Hurricane Katrina, the main legal advice we would get from attorneys was like, make sure no one talks about their immigration status, right? No one should talk about whether they're undocumented or not. This is something that should be kept secret. This should be held private. This is the best defense that people have. This is simply not talk about their immigration status. You know, in that time, immigrant youth kind of came and like blew that shit up, right? They were like, no, actually, we're going to come out of the shadows. We're going to take a lot of lessons. For example, a lot of the immigrant youth folks came out of the LGBTQ movement. They were like, we're going to come out of the closet. We're going to come out of the shadows, right? We're actually going to talk publicly and openly about our status and what that implies. And that was a really radical shift for a lot of folks that had for a long time been saying, no, we actually have to make sure that people stay silent, stay, discreet, make sure that they approach the right way of having this conversation from a place of appealing to people's compassion and honestly like pity, right? Like that was really the place of where people were trying to shape the conversation. And so immigrant youth kind of came, blew that up, gave us a different framework, and then we started to see deportations. And I think what's important to note about deportations, and particularly deportations under Obama, is for a long time in this framework of trying to fight for citizenship, there was this idea of like, there are people that are worthy of citizenship, quote unquote, good immigrants, right? Especially if you graduated from Harvard, especially if you've only worked your whole life, if you've had no interaction with the criminal legal system. And there's bad immigrants, folks that do have criminal convictions, folks that have not studied, folks that are not contributors to the capitalist economy, and those people should be expelled. There was this idea that if we do a lot of if we do a lot of deportations, if we do a lot of enforcement, if we build up policing systems, that will create political space to try to pass legalization. What we realized is we got a shit ton of deportations, we got a lot of enforcement. The Department of Homeland Security is now the biggest police force in the country. And turns out we haven't had legalization processes through the legislative process, right? And so I think for us, there was just a very false political conversation that was having there. One that was being led by attorneys, one that was being led by particularly white policy organizations in terms of what is the path for liberation. And what a lot of folks in the immigrant rights movement realize is that we actually have to confront deportations, not as a legal problem, but as a political problem. Because time and time again, we would have people who are in deportation proceedings, who are in detention centers, who are on, being boarded onto flights that had no legal recourse. We actually couldn't, they had a final order of removal. There was nothing to be done. ICE had already told their attorney nothing could happen. But turns out that when people organized, when people put political pressure, when people went to the media, when people put their bodies on the line, we were actually able to get people not only off of planes, but back into their homes with their families. And so that process was actually really radicalizing in the sense of trying to think about this problem from a different lens. And, it always reminds me, I think, wealthy people always ask their lawyer, I want to do this. How do I do it? A lot of times in movement, we ask lawyers, what can I do? The wrong question, right? We actually have to, it's both not only on the lawyers in terms of how they respond, but it's also on us as organizers in terms of how we pose the question of what are we trying to transform and how do we use legal frameworks to be able to push that open? At Mi Gente, we talk constantly about we have to build power against the state, we have to build power within the state, and we have to build power without the state. There's a lot of different places where we're contending for power. And so sometimes we do protests, sometimes we work on elections, Sometimes we do courts, sometimes we do lawsuits, sometimes we do litigation, sometimes we do a direct representation, but we have to think about it within that same framework that's taking us to a path towards liberation, not consistently reestablishing the systems that are keeping people in the same deportation proceedings. And so I think for us right now under the Biden administration, we have the same kind of issue at hand. Biden issued a 100-day moratorium on deportation. We're probably going to lose that in the courts, right? But what we're not going to lose is actually the potential for this administration to think about how they are going to dismantle their enforcement machinery. So we might not get the 100-day moratorium, but we will get 100-day review of how do we actually start to tear down this system to ensure that we have less ICE agents, less programs for deportation, and less people being expelled from the country, to be able to continue to challenge this rhetoric that we have to have enforcement to have a path for citizenship. I think there's a whole second conversation about if people do have a path to citizenship, does that actually mean it wouldn't be beat, right? A dignified life, does that actually mean full rights? Or is that gonna once again, continue to be part of a second-class citizenship that this country and this nation has always created for people of color? And so I think there's also a huge other challenge there in terms of how we're combating the frameworks of thinking about citizenship as the end goal and actually thinking about full dignity and access to human rights as actually the way that people are able to have different relationships with themselves, with each other, and with the state. And so I think there's a lot there to kind of continue to unpack, but to me at the core is that in this moment, we have to see this as an opportunity, not only to get legislation, but as an opportunity to pull the executive to actually dismantle the police forces that have been set up at a federal level, and have that be kind of the opening of how we start to break those things apart. I think the obvious are deportation and detention, but I think we'll also have to talk a lot about the surveillance machinery that has been built up, because I think tech and data in a lot of ways are starting to serve as the next chapter, right? I always say organizers, we have a really hard job because it's we're trying to dismantle a couple hundred years of horribleness. And we're also trying to figure out where are they going with this? What's the next chapter? What's the next way of state control and corporate power that's going to be trying to control, our communities' lives? And so I think that's a little bit of the next challenge that we have ahead under the Biden administration.
Thank you for that, Jacinta. I think I was particularly just, remembering that time when there was such a tension around CIR, Comprehensive Immigration Reform advocates, and people on the ground, especially the Dreamers. We received a shout out in the Q&A box that this conversation is really resonating with some of our undocumented students that are tuning in right now. So I wanted to let you know that and just say, this is a really real conversation right now, that just because we have a Democratic administration doesn't necessarily lead to liberation in any of these areas. We don't have a cancellation of rent. We don't have, of course, we're just in the beginning of this administration, but we have to keep up the pressure. We have to keep these things moving. And so I'm just thrilled to put all of you in conversation with Robin D.G. Kelley, who, as Dean said, is just an inspiration for so many of us. His articulation and interpretation of Cedric Robinson's work, his historical deep dive into so many different areas, including racial capitalism, is just so remarkable. His book, Freedom Dreams, The Black Radical Imagination, was published in 2002, but still is, a treasure trove for many of us interested in history and social movements. Scholars and grassroots activists, are bringing it into their work all the time, especially now since the rebellions and uprisings over, almost a decade now. But Robin, how did we get? Wait, let me see. Let me make sure I'm asking you my right question. Excuse me. Yes. How did we get here? And yeah, how did we get to where we are today with the multiple rebellions? How should we think of reimagining law? And what are your reflections on Freedom Dreams today? And I invite you in this answer to think about anti-fascism, anti-colonialism.
Right. Thank you, Sunita. First of all, I'm such a fan of everyone here. I've learned from everybody. going way back. Marbre started teaching me when she was an undergraduate in my class at Columbia years ago. I won't say how many. So just to say, and also I want to apologize because for various reasons I couldn't see all of the talks yesterday. I know that this is an amazing symposium. The 2020 protests, which I think the media misrepresents as like the George Floyd protests or the anti-police protests, really I think laid bare the limits of law as a strategy and as a terrain of struggle. I mean, we tend to think of law as a structure that we either work within or work around. Especially this panel and this whole symposium recognizes the limits of law, and we're all clear that the law is an expression of power, of state power, both in terms of what laws exist and how the law is applied. And so remember, in the rebellions of 2020, in fact, all the rebellions of the last, not just 30 years, but the last couple hundred years, they really struggled around two things simultaneously. That is a struggle to change the law and a struggle to apply the law, the existing law, in this case, prosecution of police officers. And in the meantime, while all this is happening, we witness an emergent abolitionist movement, like what everyone here on the panel has talked about, that was questioning and is questioning the entire structure, asking, what does accountability actually mean? What are more appropriate ways to ensure public safety? How do we transform the society so that the very conditions of precarity and the ideologies of patriarchy and racism and the economic inequality that kind of lead to the violence, are all eliminated? How do we do that? And of course, these are not new questions. These are the fundamental questions of struggle in the law itself. I mean, I'm reminded of Peter Linebaug's incredible book, The London Hang, that links changes in the law to struggles over rights and privileges of working people. And he talked about how during the 18th century, the London poor showed increasingly less respect for like newly created boundaries of private property, like enclosure. And just to add to a point that Marbre brilliantly laid out, Linebaugh reminds us that there's no evidence, for example, that the death penalty reduces crime of any kind, because as he points out, the pickpockets did their best work at public hangings, and Malcolm X actually made this argument on a debating team when he was in prison. At the same time, speaking of the limits of the law, when we revisit 19th century abolitionist movements in the US, we can clearly see the limits of legal thinking. I'm surrounded by historians who will argue with me saying, well, what could Congress do? What could, the liberal constitutional abolitionists, they're wringing their hands around whether or not you violate the Fifth Amendment by taking people's property. But of course, we know that Black abolitionists and revolutionaries, like Harriet Tubman and John Brown, never considered the Constitution even relevant to the question, because there can be no property in human beings, period. This is a crime against God, a crime against a higher order. And as Cedric Robinson talks about, in the Black radical tradition, you're coming from an ontology, a way of thinking, which you can't have property in human beings. But that's where the fact that people are still writing books trying to show that, well, you had to have a civil war in order to justify through, like military laws that would allow you to take property. That's sort of, again, another example of the limits of law. But finally, sort of what's striking about, again, the rebellions of 2020 in the movement that we've just seen basically over the past 10, 20, 30 years is that so many people have embraced calls to abolish police and prison, to shift resources to housing, universal health care, living wage jobs, universal basic income, green energy, a system of restorative justice. And the idea of abolition has really taken hold in ways that have disrupted, if not, shattered America's liberal illusions. And the rebellions were not just anti-fascist response to Trumpism. They were a culmination of long-standing struggles going back before Trayvon Martin, going back at least to the 1990s, in opposition to kind of Bush-Clinton era neoliberalism, the war on drugs, the war on terror, anti-Black and anti-immigrant racism, prison expansion, police brutality, gendered and racialized violence against women of color, queer and trans people, and just the ongoing struggles for reproductive justice. And it's not an accident that the most radical challenges to racial capitalism, just a reminder, take place under what we call liberal regimes. I mean, we always talk about the 30s. The 30s is the Roosevelt New Deal era, but it's the 30s of the period of mass labor rebellion and working class struggles. The Johnson era of the Great Society was exactly the era of some of the most important mass insurgencies. And of course, Clinton and Obama eras are also, we see the same thing. So if we look at the Capitol insurrection, the last thing I'll say is that I would argue that it was a fascist response to our movements. And I think it's important to remember that the movements for racial justice, the movements for transformation created the state of emergency, not the fascists. The fascists didn't create the state of emergency. The state unleashed its coercive powers against us alongside, using fascist methods like the police, ICE, National Guard, and encouraged mob violence in right-wing organizations. And then as Dean had made a very important point, we're told we have to then pull back, and Jacinta meant the same point, pull back, get Biden elected, get rid of Trump, and then create the conditions of a peaceful transfer of power to a liberal regime. Quiet down and let the system under good hands do its magic. And this is one of our concerns, and one of the things I'm really terrified about is that the fascist threat, which wasn't the cause of the state of emergency in the first place, is what's used, that and the rule of law is used by liberals to crush the insurgent movements of spring 2020. So we have to be able to get back on track. And I think everything laid out in this panel is exactly the track we have to consider. What does it mean to push for transformative change and transformative justice and really reorient our whole society in ways to never give that space up? I'll stop there.
Excellent, thank you. I really, that was wonderful, thank you. I, part of what I'm hoping we'll do is just have a cross exchange at this point, and I know Dean and Marbre wanted to get in on the conversation and say more about how change actually happens, kind of in dialogue with Jacinta's point. And so I'm just going to open it up to the two of you. I wanted to also mention there was an exchange in the last session around the funding for public interest lawyers, and that structure being very fraught and sort of embedded in capitalist culture. And then also there was an exchange around the value of legal aid and legal services versus sort of impact litigation. So I'm just throwing that out there as sort of part of this whole question around what does change mean, and what most of our audience is going to be lawyers or law students. Like what do you have to say about the role of lawyers and law students?
Thanks so much. Yeah, I mean, I just want to lift up, Jacinta said this really important thing, which I think actually underlying assumption of all the panelists that I want to just bring to the surface because it's the opposite of the underlying assumption of law school. Jacinta talked about that when it didn't work to go through inside strategies, what people have found again and again in the migrant justice movement and every other movement is that mobilizing actually could get people out of jail or could get people out of deportation proceedings. That it's like that when we win when we use bold tactics that are outside tactics, and that if we just are like, oh, if we bring the right lawsuit, if we bring the right bill to the legislature, we get exactly what those systems are designed to deliver for all the reasons Marbre talked about, like of how they were designed, of who runs them, of who they're beholden to, et cetera. And I think this is pretty much invisible. In our society generally, there's a story about how law is how you change lives. And that story is based on an anti-Black fake narrative about the history of Black liberation movements that says that 13th Amendment, the Civil Rights Act, et cetera, freed Black people and now everything's great and there's no more anti-Black racism. And that I think has just like very few people are able to hold on to that lie as closely as they used to. And yet it is a platform of the Democratic Party and of like liberalism in the United States and that kind of white nationalism that is actually like through and through like our whole most visible political scene. But what movements know and have always done and everywhere is like people power, you know, it's like that's the big secret. And it's not that lawyers have no role in it, but it's a totally different role than the one we're being trained for. It's not like you're going to save your community by going out there and being the person for your community who has a law degree. I mean, that is really like why so many of us come to school. Or it's not like if I just do these eviction cases or these welfare benefits cases that I'll ever get to the bottom of the pile, right? Instead, I'm just enforcing the rules of the social services system and the courts, which basically means a very small set of people have a path to immigration or have a reason they won't be evicted or deserve these benefits according to this really racist, sexist benefits regime. And most people I have to be like, sorry, bad news, you lose. Or you're just going to get kicked off benefits really quickly soon, or you're still going to get evicted at the next place you have to go, or you're still going to be displaced by some other thing that is legal, you know, whatever. And so I think this key question for lawyers and law students is how do I be in service to mobilization? And a lot of times our roles is that we are part of demobilizing. We're like, don't worry, we'll bring this suit, you community, you just wait, you know? And then we don't stop the jail or prison from being built or whatever. And we also do this thing that I think is the opposite of abolitionism, which is that we think everything can be solved by a law. And so like right now in Washington here, we're fighting against like, there's a new law brought by like these purportedly progressive people around gun stuff. And they're like gonna expand crimes related to brandishing a deadly weapon in front of 3 people. And they think this is going to stop right-wingers from coming to our protests and brandishing guns. But actually, this is going to be used to put a lot of youth of color in prison, just like every other criminal law they've ever came up with. And they also have another hate crime law that they're planning, which will, again, be used to put people of color in prison. So I think one of the questions is how do we get like decenter law or become deeply suspicious of law and legal reforms and center mobilization, and then ask questions about how lawyers are sometimes have useful technical skills or can do useful immediate mutual aid to people who are being devoured by legal systems. And that's really different from thinking the answer is going to come from law or legal systems.
I wanted to just push you just slightly on that question, which is for the, you know, graduate and the person who's going to be starting at the Legal Aid Foundation of Los Angeles next year and doing housing court or doing public benefits, how do they actually see themselves in service of mobilization? What is the practical tool they need to learn now in law school? How do they do that? And that is with the understanding that LAFA is actually an organization that would embrace mobilization. Many legal services organizations don't do that. So what do they need to get in law school, but also how do they approach that work in the future?
I'll just give the shortest part of that. The main thing I say to law students and lawyers about that is you have to be part of unpaid work in social movements, that most of them just don't even have contact with social movements. And so you might be working on the housing thing, but you're not actually connected to the organizing happening around that in your city. And so you're not going to find out about the much more radical demands coming from the grassroots volunteer-based part of the social movement ecosystem of which you can be a part, but you might be at cross purposes with if you never have relationships. So that doesn't mean just come to their meeting once when they invite you. It means join groups and be part of, because that's where the action lays. That's where the most radical demands are coming from. It's always from the radical, small, mostly unpaid or entirely unpaid groups within that movement ecosystem on whatever like issue or topic we're talking about. And so that's a really different vision than being like, I'm always going to be a lawyer and that's going to be how I'm going to participate is as a lawyer at my paid job. Your paid job may be a space where you feel really deep satisfaction about radical work you're doing, but it probably won't be because it's funded by the government or by rich people who want to keep things the same. So it's like, if I want to like do something wild and cool there, I probably have to be deeply connected elsewhere and have that guide my movements and be accountable to that. And that is, I think law students need to start now trying to figure out how to get involved in those kinds of things. Because if you think that someday it's like your life is just going to be more full of work and obligations forever, you know, it's just part of it, which is cool. It means you're deep in, but it's like how to find that balance of doing both as soon as you can and realize those priorities, which is not the priorities you're being told to have.
Great. I'm going to have Marbre, Jacinta, and then have Robin reflect and respond.
No, I'm just over here doing praise dances. I mean, I think what was just said is 100% right. I mean, if you look historically, not ever, not never, never, never has law, a litigation challenge changed material conditions in the long run. And so even I think like the most kind of a lot of cases of Board v. Brown, we all know that our schools are as segregated. And that's just one example of many, like literally not ever has a court case changed or revolutionized people's actual lived experiences. And I think we all just deeply indoctrinated into this idea that like a single lawyer, often a cis man, is the one who will save us and save the world. And the reality is that that's just not been true. It's another big lie we've been told. And I think it's really important to just recognize that the law is not only like ineffectual in making sure that our people live differently, but it also maintains social relationships and it legitimizes social inequality deeply. And so whether it's now or at the founding of our nation, it's always been used to legitimize social oppression and to sanitize deep state violence, to say like, oh, this is okay because you're Black and you're property, because you are a prisoner and you're not a human. Like, there's all these ways in which the law, I think, organizes social relationships to legitimize them. And so really the law will never get us free. It's not meant to be a tool of freedom. It's meant to be a tool of power. And I think there is also this question. I had a comrade in law school who used to say, we have to work ourselves out of a job, which is often an organizing term of like organizers should work themselves out of jobs. And I think as lawyers, we accumulate some privilege that makes it hard for us to operate, I think, in a really meaningful way around social change. And so just recognizing that in a world of liberation, there are not gatekeepers to power who have to go into debt and pass special tests to be able to speak on behalf of other people, that's not actually a function of an equal society, right? And so this whole profession, I think, is also based in this kind of this project of legitimization that I think is important that we recognize. I also think, what Dean Spade said about relationships really matters, that we are so often trained to be in transactional relationships. I remember my first internship at the Bronx Defenders, the biggest critique I got was that I was too close to my clients, that I was too like relational to them, that I had too much invested in them, and that I just couldn't survive as a public defender with that kind of relationship. And I think that is intentional, that it's structured to create difference between lawyers and their clients. And even just the use of kind of clients as the mode of operandi, I think does that. And so I think it really does matter that you're in a social movement, that you have a political home, that you are in right relationship, not transactional. You know people's names, their babies' names, why they can't pay rent. Like you have a real sense of the people who you say you work on behalf of, and not just in this very kind of transactional way. So I just agree, and I think that it does matter that we show up in movements, not just as lawyers, but as people who have legal skills. And I think that happens through relationships.
Jacinta, I know you want to get in here.
Yeah, I mean, the only thing I would just kind of add to what's being said is the deep listening to organizers when they're saying what they're trying to do. Because I think when I think about a million examples of like trying to work with attorneys on different things, it's like, we'll be like, we just want to get this information. I don't care if it's through discovery. I don't care if it's through a FOIA. I don't care if it's through whatever other way. You tell me what the tools are in terms of how to navigate this, but this is the end point. And so I think there is just something there about one listening to strategy, understanding that you're part of a greater play, right? So it doesn't matter if your lawsuit loses. It doesn't matter if you don't have standing. It's like, if all you're trying to do is get through the first point, like that is actually the help or the support that's needed. And that's where people are contending for power and using it as a tactic within a broader strategy. So I think the other thing is like confusing that like legal strategy is the be all end all without understanding that it's actually a tactic that organizers are using in a bigger arc of how they're building power and how they're trying to transform the way things are being defined in our communities and what frameworks we have to fight with authorities about these things, whether the authority is the government, the police, whoever it is, a corporation, right? These are just like vehicles that we're using to be able to create that space. And so I do think just relationships are really important to that. Like when I think about the lawyers that like I fuck with on this level, like it's been 10 plus years of just actually building with each other and figuring out like where it is that we're trying to move things, how we're moving the needle, what are the policy demands, what are the litigation options, how do we use cases as part of that? So I also think there's just like so many legal strategies that we have at our disposal that it's also just a willingness to actually combine some of them and challenge them in ways that like there's just a level of conflict that we have to be used to or kind of accept. And I think that that's another thing that's really hard, especially for new attorneys, where they're like, the organizer's asking me to do something totally crazy. Like, what do I do about that? Like, there's also just something about the comfort of understanding that we're taking risks together that I think can actually be really fundamental to figuring out how we develop new strategies, especially like, I know we're going to talk right now about some of the technology things, but like, there are actually like legal frameworks that are insufficient, like in terms of how they're defined right now. So as we're thinking about how to create different definitions, different precedents, different policy frameworks, if folks aren't willing to kind of take that jump with us as organizers, or aren't willing to jump into that confrontation or into that new terrain and just stand within the parameters of what was prescribed in law school, there's always going to be tensions and limitations to how we can roll together.
Yeah, so I guess I'll jump in. I mean, there's hardly anything else left to say because it's been said brilliantly. I know nothing about law school. I do write a lot of letters of recommendation for students who go to law school. Most of them come out okay. And they end up breaking with the framework. But let me say two very, very quick things. It's, for me, thinking from my perch as a historian and someone connected to social movements, it's impossible to separate the question of the law on the mount from democracy on the mountain. The law and democracy, you know, the idea that the law is important, that legal strategies work, is tied to the idea that we live in a democracy. But the fact of the matter is we live in an anti-democracy. The US was started out that way. Cedric Robinson has written about this. That's why we have an electoral college. That's why we have representative forms of democracy, and repression against those participatory and consensus basis of democracy. The very thing that Dean Spade talks about in his book is, in fact, about democracy, democratic practice. You know, and we see these things happen in places like Jackson, Mississippi. We see it in Occupy, where there's actual democratic practices that are not based on representation, but based on something else. You know, process-oriented, consensus-oriented struggle. And that's something that in some ways defies the way we understand the law as this thing that's supposed to be above us to protect us, right? The other thing is that I worry, just right, you know, we had this conversation about this, about the way that the more radical strategies in the courtroom, especially both in popular culture and in terms of our memory, have been pushed aside in favor of legal strategy. So all this focus on the importance of progressive DAs, which is important. I don't want to take that away. I was watching this documentary about the MOVE case. And one of the things that you, in the documentary, is you come away thinking that because MOVE members wanted to represent themselves and say from the get-go that this process is illegitimate, that somehow they put themselves in prison, they undermine their case. And in comes Larry Krasner years later to say, well, you know, I actually know what the law, how the law works. And through his efforts, not through social movements, not through organizing, not through protests, not through years and years of mobilization, but because of a good DA, we're able to get, you know, members of MOVE out of prison. And that is a narrative that I think is really dangerous. And that goes back to everything that everyone said about the limits of legal strategies, but also what the law is supposed to do and how it functions. Not so much for, you know, within an anti-democracy, it functions for the sake of maintaining power for those who rule, not necessarily for freeing those of us who are living under this kind of extractive, oppressive systems of capitalism, racial capitalism. I'll stop.
That's great. I mean, I wanted to, Jacinta, I know you wanted to help us understand a little bit more about tech, especially as we move into thinking about what's going on with health and tech and COVID-19 and surveillance more generally. So please, you know, break that down for us.
You know, for me, it's important to as we were talking before about the context around trade-offs around legalization, right? Where it's like this idea of you have to have some sort of enforcement, you have to have policing, you have to have deportations as a precursor to be able to create some sort of pathway to citizenship. I think what we're seeing under the Biden administration is that there's an extra emphasis that's been kind of growing and expanding for many years now, of this idea that we need to have more tech and surveillance as a form of enforcement to be able to provide some sort of security that then would allow for political space to have legalization. So we saw it, for example, with Biden introducing his framework for a path to citizenship, where he talked about, getting rid of Trump's brick and mortar wall. We have to step away from that, but we actually have to invest in a surveillance wall at the border. That's pretty consistent with the mission of CBP, Border Patrol, and ICE, Immigration and Customs Enforcement overall, since they were formed under the Department of Homeland Security after 9/11, where under the guise of defending the homeland, you basically establish the framework for creating an international surveillance agency that is not only surveilling immigrants in the US, but immigrants that are trying to come to the US. And so through that, you're able to kind of create a broader and broader network. And the thing that you have to understand with this is, even though that might be the legal framework under which they're kind of creating these policing practices, you also have it is situated within capitalism, right? So you have surveillance capitalism overall that is creating this whole system for the buying and selling of our personal data and information, right? Which is literally stealing our most private information about ourselves and selling it not only to corporations, but to policing agencies that have an investment in policing Black, brown, and immigrant bodies in a particular type of way. And so the thing that's actually interesting to me about this, and the reason to bring it up in this panel, is that many times the framework that people talk about to be able to fight against this is privacy. And it is not only not winning any political battles, it is not only not moving our constituents and our bases, but it's also insufficient legally. And so it actually gets in the way of thinking about how do we get the Fourth Amendment to actually include some of these things? Is that the path or is it not? Should we talk about a different way of conceptualizing of some of these concepts? It becomes a very, very kind of complicated mess in terms of both figuring out strategy and macro goals in terms of what are our aspirational places of how we're trying to understand these issues, to be able to limit the way that the state can use these types of technologies that are outpacing our legal systems, right? So you have like a legal framework from, whenever the Constitution was created, and then you have Silicon Valley breaking things and figuring out how to resolve them later. And so how you actually figure out how you address those things has become a really difficult terrain, but one that we have to understand and conceptualize as an expanding of policing, not as someone trying to create a more less violent alternative, right? Which is many times the way that it's portrayed. So it's like, let's move away from cages and have ankle shackles. Let's move away from cash bond and have algorithms. Let's move away from racist police officers and just have racist algorithms. And so there has to be one, like, we're pushing back against that in social movements and trying to get people to connect those dots. But where I see the biggest gap is actually in the legal framework, where people are consistently providing us with just really outdated systems that are not going to, again, both move the masses, move the government, or move the law in the direction that we need. And so I think this is a place where we actually have to be more expansive of thinking of this. And part of the reason why it's so terrifying and so important is because under COVID, under the pandemic, we start to see some of the same companies that have been the architects for ICE's surveillance system now saying, hey, not only can I custom build software for ICE, I can custom build software for Health and Human Services and the IRS and the census. And by the way, that company is called Palantir and funded by Peter Thiel, a white nationalist who has a lot of right-wing ties, who has been supportive of the Trump administration and other right-wing movements. And so you start to understand how there's a need to be able to contend to power, and there's actually a need to be able to use both policy and litigation frameworks that will support these movements. But if our imagination is this big on how we actually confront those issues, we're going to continue to be on the losing side of this. And so to me, this is just kind of like an invitation for people who are listening to the panel to think about this as the new chapter of policing, the new chapter of state control, and also the new chapter of neoliberalism and private private-public partnerships in terms of how these things kind of come together as both not only an economic model, but a model of social control and policing that continues to kind of target folks that are sort of seen at the margins, even though really that's kind of like the future of what all of us are going to be confronting very soon, because we know that these are just kind of the testing grounds in terms of how they're thinking of using this technology.
Terrific. Thank you, Jacinta. So I'm going to ask one question and just open it up for everyone, which is, part of what we really want to do is think about freedom dreams and reimagining what we want for tomorrow. And so what, for you, if we were to imagine different tomorrow, what would it include? And I'm going to incorporate here a question from our audience, which is, who would be involved in those conversations? Who would be at the center of those conversations, and how would we structure them if we wanted to do that? And I'll leave it there. Thank you. Maybe Robin, do you want to go first this time?
I guess I have to be ready. What am I looking for the future? Retirement. Okay, I'll move that to the side. This is a great question. And let me just say two things in answer to the question. In terms of the last part of the question, which I think is very important, who would be involved? All of us would be involved. This idea of expertise, this idea of, that somehow there are people who bring a certain kind of knowledge and their think tanks and all this stuff, that's really the greatest problem that we face. If we really want to talk about, mutual aid as a practice, then it means every single one of us have to be in this conversation. It's a messy conversation to have. And when we talk about accountability and abolition, you don't just take the people who wrote the books about abolition and put them in a room and come up with a solution. You've got to move people towards something which just seems like a dream, but actually it's more consistent with global society. Restorative justice has a longer history than the prison house. I mean, that's just true. But to go back to this other thing, what's great about this panel and everyone on it is that we have I exclude myself and I exclude you, Sunita, as well, is that you're talking about thinkers and activists who really, are pushing towards a liberatory future and thinking about the three things in these pillars, that is transformation, accountability, and a kind of radical reorientation of social relations and thought, that is ideology. And what you're all doing is the critical work of liberation, the work of abolition, whether it's movement lawyering, architects of visionary policy, resisting carceral state and national borders, building new communities through mutual aid. That is the future. And it's happening now. And it has to happen again in struggle. It can't happen like in symposia, though symposia is important to bring us together. But there's another kind of format for symposia that's taking place. And all four of you are involved in movements where that's happening, in Movement for Black Lives, in Mahente, and all the work that Dean's doing in the Seattle area, but also around both housing, trans rights, all that stuff is all right before us. And so for the people on the call, it's important to participate, join in movements, because that's when you're going to get conversations with people for whom the impact is different than maybe for some students.
Yeah, and I'm just going to jump in here too before we transition, which is just to say, part of our job as law professors, or at least I take this as part of my role, is to suggest to students that they need to be not in proximity to power, but in proximity to justice and injustice. So they need to really see how this works on the ground, and also challenge their own idea of expertise and what we develop as lawyer privilege, right? We speak a certain way, we have access to power. Now, a lot of us know a lot of people in this administration. How are we going to use that? Are we going to be the gatekeepers of, continue to be the gatekeepers of knowledge production and reform or not? So Marbre, you want to go next?
Sure, I can go next. Yeah, you know, this is a hard question for me. I feel like I have kind of two thoughts or responses. One is around, I think the future that I imagine, and I imagine it with organizers and folks who I think are the most imaginative, the most radical, the most creative, is one in which it's, you know, everybody has a role in helping to create it. And so I do think to that point, I mean, I think our role is different. And the people who have the biggest kind of outsized role right now, folks with power, and I feel like there's an inverse of that, that, you know, we value the expertise of folks who have to live through these systems as opposed to the expertise of like schools that put you in debt. There's a real, like, there's a difference about kind of who we think actually has the expertise. But I mean, I often think about this as kind of characterized by a set of politics. And so I really, in the last 10 or 20 years, have adopted a series of politics around abolition, around Black queer feminism, intersectionality, and around anti-capitalism that I think really like dictate my imagination of what's possible. And so I think when it comes to rejecting the capitalist system, that means that we no longer think of people or this planet as disposable, that we really embrace a idea of how we actually interact with both the planet and other people and animals on it in a way that's rooted not in exploitation, but in love and in, I think, collectivity. And then I think in terms of intersectionality, that is a frame that really centers folks who have been most marginalized. And so that is disability justice frame, that is a frame around Black queer feminism, that's an embracing of how do we actually like take the margins and put them in the center and solve, I think in the kind of the tradition of the Compy River Collective, how do we solve for the most marginalized to actually have a solution that fits everybody? And I think that they often, you know, when we're talking about past movements, it really does center Black, cis, able-bodied men the most. And so how do we actually move away from that and think about a more holistic solution that centers folks who I am not, but centers folks. And then lastly, I think abolitionists, which is really about transformative justice and about where it is that we're putting our attention and our love and our care. And so how do we actually transform systems and not just kind of put bandages on them? But one thing I will say, and this is a quick story, is I think am constantly recognizing, because of my age and my education as a lawyer, the limits of my own imagination. And I remember I was a baby lawyer. I was probably like a year or two out of law school, and I was doing police reform. And that meant that I kind of had a list of like ways I thought we could help reform the police that had come from different kind of policy shops and different like grass tops and grassroots organizations. And this is after the killing of Michael Brown and Sandra Bland, and kind of in the year 2015 and 16. And there was another very similar movement and outcrying against these systems. And unlike this movement, the cry was around kind of accountability versus defund. And so I think even the work we've seen in the last 5 years, but I was like, this was my kind of thing. I was like trying to write policy in different places to support people in police reform. And I thought that I had kind of stretched myself. Like, this is like oversight, community oversight of police. How do we think about like different accountability mechanisms? And I went actually to Minneapolis, and it was right after the killing of Jamal Clark, who was one of literally dozens of Black and brown folks who've been killed by the Minneapolis police in the last 5 years. And a group of activists and organizers had occupied the precinct, which is amazing and ridiculous, right? So literally had put their bodies on the line in the middle of Minneapolis winter, which I'm from Cali, is not a joke. It was cold as can be. And they had occupied the precinct. And I went in to help them figure out like, what's the demands that y'all are thinking you want? How can I help you rate them? And I kind of get there, and I have my like list of like, do you want community oversight? Are you looking for body cameras? Don't do body cameras, by the way. And Candace, who's one of the organizers there, and now one of the kind of founders of Black Vision Collectives, who was the spearheading of much of the work that happened, said to me, like, she's like, thank you, that's helpful. But actually, we want to abolish the police. What do you have anything in your kind of toolbox for that? And I froze. I was like, no, like, I don't have a legal solution to abolish the police. And I hadn't thought about it. Like, as a 29-year-old young, like hotshot lawyer, it didn't occur to me that a demand was to abolish the police. And so I think I want to say, and really think about that idea that I think so much of what we think is possible is limited by our, like, where we've been, what we've seen. And then I think the invitation with organizers, with being in community, with having a political home outside of a legal home, is that what you feel like is possible is stretched. And what I spent all night up to my credit, I was like, okay, we're gonna figure this out, and came up with some invest, divest kind of ideas, which they already clearly had and had been thinking about. But what it taught me to do is to not say no. That I think the like instinct of lawyers and legal workers and grown folks, quite frankly, is to be like, nah, like not possible, not doable. And instead of saying no, I think leaning into how, and what does it mean for us to actually meet people's imaginations into the possibility of making it real. And I think we have to reject the idea that what has been is what limits what's possible. And law school is all about indoctrinating us into that is the case, that nothing that hasn't been said that isn't precedent can be done. But I think that so much of us imagining a new world is about us being in a collective place of yeses and of hows together.
Snaps to all that. So let me do Dean, Jacinta, and then I want Robin to have the last word.
Yeah, this question about like what we are imagining in a new world, like I just want to take a second to, like, we've raised up all these ideas about like collectivity and justice and connection and democracy. And I think it's really hard for people to picture what those things actually look like in the society we're living in. So like, I'll just share some things I see when I think about that in my mind. You know, during the Occupy moment, a lot of people talked about this phrase, everything for everyone. And that is so beautiful to me. It's like, I dream of nobody having more than they need and everybody having everything they need. And all the systems we're describing, capitalism, the prison system, the borders, the US military imperialism, all of these systems are designed to extract and concentrate like everything in the hands of the fewest people. And they've been doing that my whole lifetime. They've been doing that really well. It's just gotten worse and worse. Like that's, and meanwhile, they've told us that racism is over and that queer people are equal and all these things. And that's not what it's like, actually. This, you know, Marbre used the term material conditions. It's like, that is where we have to look. And so what I imagine is a world in which no one has a landlord, no one has a boss. You actually have a say in where the energy comes from and you're part of the grid and it's run collectively together. You actually have like, nobody far away in DC or in some corporation is deciding like the quality of the air you breathe, the quality of the water you drink, whether or not you'll have food, but instead that we have this kind of collective self-determination that is like networked, but has this local level. And I raised as one of the questions asked in the Q&A was like about whether or not mutual aid is like just too small scale or like can't really get us where we're going. And that question usually comes from people who really strongly believe in a state, which is a concentrated extraction machine that then is supposed to give back things to all the people in the right amount. And when you live in the government, the nation states in the world today, but certainly the United States, which has founded colonialism and white supremacy and slavery and patriarchy, it's never going to do that. Like that's not what it was made for. It's not going to do it. And so instead, many of us believe that we want to take back this kind of ability to determine our own lives together, not in this individualist kind of like, you know, white libertarian thing, but instead this kind of collective self-determination. And that means we decentralize and be in deep solidarity. It's a different kind of networkedness, and it's not bringing up to scale, meaning the scale of the government of we'll take arbitrarily this huge amount of land and say it's all one thing and then have these few people run that for the best extraction, but instead take it up to scale, meaning networked, consensual, real people getting to like choose and participate in their communities in all these ways that involve local wisdoms. That's really different than having somebody in DC decide that it's okay that you breathe toxic air in Louisiana, you know? So that's like the biggest way of thinking about that. And also what this means is a kind of practice between ourselves of desiring other people's participation and wanting to know that what people who disagree with you think and wanting to know how this is affecting people different from you. And I do think that the disability justice movement is the space where we're seeing some of the greatest wisdom about what it means to practice actually desiring each other's participation and encountering our differences with like a curiosity and respect and interest. And so I will just briefly nod that like that, if you're not already deeply following the wisdom emerging from those movement spaces about how we be together in a way that's not about creating centralized standards and then applying them to everybody and like losing everybody else who can't meet whatever that arbitrary standard of what a proper body or mind is, right? That's like a space I look. Obviously, feminist, anti-racist, all of these traditions, they all have contributed to our ability to think about how to be together differently. So it's like we are practicing on the most intimate levels and the most transformative visionary levels at once. And that requires a lot of us. And a lot of it is about shaking off the idea that things can't be another way that all of us have rejected during this conversation, and taking off the idea that there is no alternative and it has to be the way it is, and grow up and see that everybody's naturally greedy, or whatever story we're being told. And instead being like really imaginative and then really practical. Like everybody has been in this conversation, like what's the next step right now in our city with our city budget to have the police get smaller and childcare get bigger? Like that, it's that combination of like big thinking and like practical next steps, and making sure that we're not being tricked into next steps that actually are harmful to our communities.
Thank you. Jacinta?
This is a hard question, and a lot of, like, it's like an easy question but a hard question, because I think one way of answering is we need everybody on board, right? Like when I think of, for example, the No Tech for ICE campaign, like we've had to develop tactics literally from like undocumented folks on the front line having to confront ICE, city council people, lawyers helping them out, students that are being recruited by these tech companies, tech workers themselves, investors. I mean, talk about not the path to liberation, like talk about a Wall Street strategy, right? Like we actually have to create a pot where like everyone can have their role and be thinking about what their contribution is to movement. So in the broader sense, it's like we all have to be thinking about this, and we all have to be thinking about how we chip in. In the smaller sense, it's also like we can all theorize to death about like what is the path to liberation and how are we helping each other. But it's like, if you're not organizing, if you're not actually doing the work of like participating and building up institutions that are helping to organize, if you're not actually thinking about strategies, if you're not actually pushing back against power, it's like there's just a way in which we actually have to get into motion and into movement and get into relationship with each other to be able to effectuate these things. So like, shameless plug, if you're Latinx, Chica Next, and are listening to this and are like, not only do we have to be pro-Latinx, but we have to be pro-Black and pro-women and pro-queer and pro-trans and pro-Pachamama and anti-corporation and all of those things, become a Mi Gente member, roll in, let's figure out what your role is, what your place is in all of this. Because I do think like a lot of times I think we kind of are waiting for the perfect solution. We're waiting to figure out like, what is the North Star that we're all going towards? And a lot of these things, I think from some of the stories that people told, we actually figure out while doing them. We actually figure out while in campaigns, like this is where we actually see our contradictions and our conflicts come into like live moment and figure out how to move through them. And so to me, it's just also an invitation for people of like, it's not a question of sitting on the sidelines until we have the perfect answer. It's actually about how we figure out how to be in relationship with each other as we fight for power and against the power that is trying to oppress our communities, that we figure out what those solutions are. So just kind of like, we're not going to figure out the perfect, like way of figuring out how we get to abolition. We're not going to figure out the perfect way of getting towards liberation. We actually just figure out how we respond to the moments that we're in, and how we develop relationships with each other that actually give us the fortitude to be able to resist in moments when we're under attack. So I think it's just a question of how we build a political family for each other.
Thanks, Jacinta. Robin?
Yeah, well, everything, like I said, it's been said just beautifully. Anti-capitalism, capitalism has to end. America as we know it has to end. The colonial reality that we experience has to end. These are just bottom lines. The liberal democratic state that we keep turning to is incapable of making any of this stuff happen. It's a side of struggle, but it has to end as well. And it should be, that work should actually be the starting point in some ways, not the end point. Because one of the things I just want to just caution is that there's sometimes we think that we're trying to reach the end of history. Like once we do these things, we'll be free. But it produces a new set of relationships which always tend to reveal other forms of oppressions, other forms of inequalities. So this is a constant struggle to change ourselves and change our society and change the world that we live in. That's never going to end. And that's kind of exciting when we think about it. But it begins, I think, in terms of what everybody said, in how do we relate to one another in the movements that are trying to change this world that we live in, and one another is not just within the nation state. So I think there's a lot of lessons we can learn from all the movements in the past, indigenous movements, disability movements, queer, trans feminist movements, all these have taught us, how to fight, but most importantly, how to live and love each other and the earth.
What a beautiful way to end. Thank you. I want to just, again, thank this group of people, these minds, for all their work, all their, everything they do to generate a different world for us, and really just to appreciate you. We are out of time, and thanks to the audience as well for hanging with us. We're going to have concluding remarks. And I'm also going to bring on our symposium team and our next year's editor-in-chief. Thank you.
Hi, everyone. Thank you again for joining us. Once again, my name is Ryan Garcia. I'm the UCLA Law Review Symposium editor. And I again just want to thank you all for joining us for these critical conversations. I'd also really like to thank our co-sponsors for supporting this event. And I do want to take a moment to reflect on some of the amazing conversations that we've heard over the past few days. And I want to really, really thank all of our esteemed panelists for engaging in these extremely crucial conversations to move us forward. Before I started the symposium, I was told by another student that they remind themselves weekly of something Marbre told them, which was that the law school is the indoctrination of limitation. And this is something I was thinking about during Purvi Shah's remarks, where she said that law is a malleable tool, and keeping power in the hands of the white, wealthy, and powerful is what it does. So again, to kind of bring back her comments, we're not just changing policies here, we're looking to change culture, systems, and power. And so we do need to find a way to stop perfecting and thinking that we're reforming systems in place. And instead, as the symposium has suggested, reimagine and create new systems. This is why any liberation work must be grounded in abolition. As Dean Spade mentioned, we must decenter the law, and we win when we use bold tactics and outside tactics. Thank you, Dean Spade. I just want to address Professor Sosi, my queen, my blueprint, Nayan Chinaki. I appreciate you. Professor Sosi's comments resonated deeply with me as a student of Indian and tribal law and international indigenous human rights. She reminded us to think about the way we teach and learn Indian law. For instance, my property professor refused to teach Johnson v. McIntosh or engage with students about Indigenous peoples and issues. So I want to remind everyone that our narrative as Indigenous peoples does not begin or end with colonization. Our history should not just be taught, and sometimes they're not even taught at all, in narrow colonial frameworks. Again, UCLA as a land-grant institution, we do have a powerful role to play in this, but not the only role. So I do just want to end on this note here, that critical race theory and critical race studies as a field has been built by people of color for people of color. We do know, however, that this functions at many intersectional levels. Thank you again to Kim Crenshaw for leading the way in this. Critical race theory has transformed institutions like the UCLA Law Review. I'm so proud to be a part of this organization that continues to push our law school to do better. I'm also proud to have an incoming executive board that are all critical race studies students. I want to again thank our editor-in-chief, A.K. Shih, for continuing to lead us through this and get us to this point. Here's A.K.
Thank you, Ryan. And hello, everyone. Well, I certainly think it's been a pretty fantastic 2 days of conversation. Thank you all so much for sharing this experience with us. Again, my name is A.K. Shih, and I am the Volume 68 Editor-in-Chief of the UCLA Law Review. I hope you enjoyed the panels and that you found the discussions as provoking and galvanizing as I did. Thank you also for bearing with us as we navigated this virtual platform. While this format has provided us with new challenges, it also meant that we could expand our reach beyond the law school's walls. Law is experienced by us all, but shaped by few. This means that we have a heightened and collective responsibility to answer the call that has been put forward by our amazing panelists and speakers. These lawyers and activists have recognized and named harms that have long existed. They have also imagined a better future and suggested work we can all do to build that future. Now, in my closing remarks, I originally wanted to tie together a few major themes of the symposium, but I struggled to narrow and isolate any of the many themes discussed over the last 2 days, and I realized it's because all of these topics exist everywhere, no matter what spaces we inhabit or what interests we hold, and we must look at the fuller picture in order to identify how we are each positioned within the broader movement for liberation, so that we may better incorporate this awareness into our work and our daily lives. Even now, as we live in a world with a seemingly endless array of compounding adversity and hardship, this is not the time to look at the state of the world and to give up hope or to fall into complacency. There is always a next step, always a way to continue uplifting marginalized communities and protecting those who are targeted by systemic violence. And as I mentioned in my opening remarks yesterday, the core of the symposium is about imagining a different world. But the symposium itself was just a small step, a small push, challenging us to reframe the ways we think about our positionality in this world and to educate ourselves on how we can do and be better. How we must consciously work to be anti-racist and, as T.L. Lewis spoke of, be anti-ableist every day. And reimagining, we are reminded by Professor Sosi that sometimes we don't always need to think of something totally new. Sometimes we need to think of what white supremacy has tried to eradicate, what it has taken from so many people in shaping the fabric of our so-called democracy. I'm sure many of you in the audience are familiar with the role and function of law reviews in shaping legal discourse. It is one of many tools that may be used to engender expansive change, but in themselves, law reviews remain a highly institutionalized arm of an oppressively hierarchical social and legal system. And I believe it is worth noting clearly that while the scholarship published by law reviews play an integral role in the continued advancement of legal analysis and the evolution of policy, the intended audience for law review publications remains largely insular and exclusive. The UCLA Law Review aspires to live up to the responsibilities we hold by virtue of our privileges and utilizing our institutional power to expand our accessibility and to be very intentionally people first in the work that we publish. Because academia, for the sake of academia, too easily devolves into complacency under the guise of growth. So, to use some of Dean Spade's words from all the way back in a 2008 LACRate conference, we at the UCLA Law Review have aspired to build a space to specifically resist limitations of academic culture. The values and principles of our journal, values opposing racism, opposing ableism, homophobia, transphobia, and more, they are not only exemplified in the topics and participants included in the symposium, they are also at the heart of everything we do through the UCLA Law Review. Our goal over this past year has been to publish authors who are not just writing about today, but who are thinking about tomorrow. We are so proud to have hosted so many of these authors at this symposium, and we are honored to have the opportunity to publish their work, because lawyers are political forces. We are not neutral actors upholding neutral laws. We work backstage to all social movements, but the sad reality is that the vast majority of us do work that protects the system. To this end, we, as law review editors, as law students, as soon-to-be lawyers, we must think about scale, and we need to have a reckoning within the profession we seek to enter, about the harm that we do and how we may better hold ourselves and our peers accountable. Like Purvi Shah mentioned just earlier today, law doesn't itself bend towards justice. Movements and people must work to ourselves compel that bend. So much of what we take for granted that we can do and talk about in law school today, like abolition and critical race theory and the role of white supremacy, is because of the panelists who were here today and so many other scholars, lawyers, and activists who have dedicated their lives to liberation. As the next generation of lawyers, we must push further. Some of that will be dismantling the very laws we spent so much time studying. This is both our challenge and our obligation as the few people who are trained to navigate an elitist and opaque institution. To learn from those who came before us is our privilege, but to continue their work is our responsibility. Now, it's a little unusual to have both the outgoing and incoming editor-in-chief speak at our annual symposium, but given the vision of the UCLA Law Review over the last year, we understand that while we inherit oppressive legal frameworks and consequences, we nevertheless have a duty to pass on a better world. And an important part of that is collective work, support, and conversation from year to year, class to class, and generation to generation. So in this spirit, I felt it out to include our incoming Volume 69 Editor-in-Chief, Alana Kane, in our closing conversations today. Alana is an amazing person, a trusted leader, and I have no doubt that she will guide the UCLA Law Review into even more critical and radical directions over the next year. One conversation that Alana and I had during this transition period stands out with particular clarity to me. She asked me what my positive takeaway was, whether this past year as editor-in-chief was worth it. And I thought about it for a second. I thought about her and the many other incredible board members in her year, and I responded yes. Yes, it was absolutely worth it. Worth all of the work, all the sleepless nights, the hard decisions, the evolving visions, because this work must be done, and it must be done by people who understand the weight of its power, because I believe that we are each other's legacies. We lift each other up while holding each other accountable, and we recognize the broader social and community duties we have born out of our position as law students and law review editors. Law school is difficult and the law itself disheartening, but I look at Alana and her peers, and I see the future scholars and future leaders of our generation. I look at their class, and I see the future of critical race theory. I see the next Kimberlé Crenshaw, Dean Spade, and Robin D.G. Kelley, and I am humbled that I get to know them now, that I get to be witness to their growth and their evolution. And on that note, I am beyond proud to be able to introduce to you our incoming Volume 69 Editor-in-Chief, Alana Kane. Alana, the floor is yours.
Thank you so much, AK, and thank you so much for those kind words. I'm just overwhelmed by your support. Your leadership has changed the landscape of legal scholarship. You have transformed UCLA Law Review. You have broken down the barriers for students of color like me by pushing forward diversity and inclusion initiatives while ensuring the Law Review took its commitment to dismantling structural racism seriously. You have re-envisioned the ways in which a flagship law journal can imagine radical possibility. So I am grateful to stand in your shadow. A special thank you to Ryan Garcia, the Symposium editor, a leader in the law school community who I have long looked up to, for her tireless work organizing this incredible group of panelists, many of whom I admire greatly and whose scholarship has brought me here today. Thank you to Professor Sunita Patel for her vision throughout the symposium. I feel lucky to be a part of it. I have to give a special thank you to my mentors, especially Professor Kimberlé Crenshaw and Devon Carbado, who moderated our panels yesterday. Like many of you all in the audience, my life has been changed by your scholarship, and it has been shaped by your guidance. I feel so grateful to learn with and from you every day. My name is Alana Kane, and as AK noted, I am the editor-in-chief of the UCLA Law Review, Volume 69. The past 12 months have laid to bear inequality is the underpinning of our political, economic, and legal structures. Black and Indigenous peoples have disproportionately lost their lives to COVID-19. 1 in every 475 Native Americans has died since the beginning of the pandemic. To date, Black people account for 15% of COVID-19 deaths. 73 million people in this country voted for a xenophobic proto-fascist demagogue this past November. There were just 18 days in 2020 where the police did not kill anyone. At a time of so much collective loss, destruction, and disparity, it can feel hopeless to imagine a new tomorrow. So I have looked to Black and Indigenous, undocumented, disabled, queer, trans, two-spirit organizers, thinkers, activists, and abolitionists, like Movement for Black Lives, Red Nation, Black and Pink, Mi Gente, who brought to life, as Prof. Robin D.G. Kelley offers, a commitment to freedom dreams. To borrow from Kim Crenshaw, we simply do not have the luxury of building social movements that are not intersectional, nor can we believe we are doing intersectional work just by saying words. Over the course of this symposium, our panelists have called on us to not just say the words structural inequality and law, but to put them to work. We have to reconstruct our frameworks. We have to claim social movements and build collective power with grassroots organizing. We have to transform legal pedagogy from a place that normalizes meritocracy, destructive competition, and shame, and bridge the silos between academia and activism. We must protect critical race theory at any cost and re-energize the next generation of scholar activists. Over the past several months, I have been reflecting on what it means to be a member of UCLA Law Review. As Purvi Shah stated this morning, what are the limits and possibilities of looking inward? What does it mean to be a gatekeeper in an academic field that has historically protected white male supremacy? To be a member of the Law Review is to wield an immeasurable amount of privilege and power. Law school students across the country control legal academia in a way that is distinct from every other profession. We choose which thoughts should be shared with the world, whose knowledges should be valued, whose perspective should shape our understanding of the law. We decide if structural inequality will continue to be embedded in legal scholarship. We bear the weight of delegitimizing and dismantling white supremacy, heteropatriarchy, classism, imperialism, and ableism. Our duty is to disrupt power and transform these systems, to decolonize and demarginalize the intersections across the terrain of legal scholarship. I am honored and humbled to lead the UCLA Law Review as we commit to the legal realization of radical hope. As we look ahead, we remain committed to causing good trouble, to push the boundaries, to publish transformational legal scholarship, and to open the gates for those law stories that are never told. We have to use the Law Review as a tool of liberation and not a tool of power. So thank you so much again for joining us, and we look forward to the journey ahead. I'd like to pass it to Professor Sunita Patel for her closing remarks. Thank you again.
I'm having a Robin D.G. Kelley moment. Nothing left to say. Thanks everyone for joining us. Thanks to our co-sponsors. Thanks to the Law Review Symposium team for all their hard work, and for everybody who did so much amazing work behind the scenes. I can't even name them all, but thank you so much. And we look forward to hearing from you soon. Bye-bye.